Aloha. Aloha, commissioners. Aloha, everyone here. We're going to call today to order. The regular meeting of the Leeward Planning Commission will now come to order. It's Thursday, December 19th, 2024, and the time is 1:04. This meeting is being streamed live on YouTube. I'd just like to introduce everybody to our commissioners. We have Vice Chair Mahina Paisan-Duarte.
Aloha.
We have Commissioner Dean Au,
Aloha, good afternoon.
Commissioner Clement CJ Kanuha,
Aloha and good afternoon.
Commissioner Dona Kaniku Noborikawa,
Aloha.
Commissioner Armando Rodriguez.
Good afternoon.
Commissioner Michael De La Cruz is absent and excused. And I'm Chairperson Barbara DeFranco, and we do have a quorum to hold this meeting. From the Office of Corporation Counsel, we have Deputy Corporation. Is everybody's on? Is yours off? Talking to us?
Aloha.
Just mine. Am I on? Okay, good. Deputy, in good timing too. Deputy Corporation Counsel Susanna Tiapula.
Aloha.
She's our attorney for the commission who is present to advise us. And Deputy Corporation Counsel Jean Campbell, attorney for the planning
afternoon.
department. Hi. And Acting Planning Director Jeffrey Darrow. And is Michelle here? Deputy Planning Director Michelle, welcome, are present to advise the commission. Commissioners, please confirm that you've had the opportunity to review materials related to the applications being reviewed today.
Yes.
Everybody has
Yes.
done this. Okay, great. So I note that each commissioner has verbally confirmed having had an opportunity to review the application materials and all submitted testimony. So a little bit of housekeeping. We just ask you all to turn your cell phones on silent. And to let you know, the public restrooms are right out that door on the right, and there are drinking fountains out there too. If there's anyone here in person who would like to testify, please fill out the yellow sign-up forms at the staff table. And also, if you have any written testimony that has not been sent in earlier, you may submit it now to staff. I just also want to note to everybody, you're going to notice that sometimes as testimony is being given, you might see someone in the planning department or one of the commissioners checking their laptops here in front of you. And this is really for gathering facts and finding out more information. We are not surfing the web or anything. I just want to make that clear. No disrespect. Okay. All right. Statements from the public on agenda items. As it's been stated in published agenda, members of the public may provide public testimony regarding any agenda item now or at the time the agenda item is called to order. Testifiers on Zoom, please keep your video cameras off and audio muted until you are called by the Zoom host to speak. Please note that this is an in-person meeting and the Zoom platform and the YouTube live stream are provided as a courtesy. Before we start to receive public testimony pursuant to Rule 1.5 of the Planning Commission's Rules of Practice and Procedure, I would like to remind everyone to be courteous and respectful to all testifiers, staff members, and commissioners. Please direct all your testimony to me as the chair, and testimony will be limited to 3 minutes per testifier for each agenda item. Okay, in-person testifiers. So we have two testifiers, but they're going to speak before the item is called. So we have any Zoom testifiers that want to speak now?
Chair, I believe those two people on your list wanted to testify at the beginning of the hearing.
Oh, okay. So we can call two testifiers up at a time. So we have Rebecca Mendez and Michelle Melendez. Rebecca Melendez and Michelle Melendez. You're testifying on items. It's hard for me to read this. 1 and 2. 1 and 2. Okay. Thank you for coming. I just want you to turn your speakers on, push that little button until the red light goes on. There's push the button on that Okay, very good. So I'm going to ask you to raise your right hand and swear to tell the truth on what you're to testify today before the Leeward Planning Commission.
Yes, yes, I do.
And then as you go to speak, I'd like you just to say your name and where you are from, the town you're from. And that's it. You have 3 minutes for each item. Okay. Please begin. State your name and what you're testifying on, the item number.
Okay, aloha, I'm Rebecca Melendez. I'm testifying on number 1 with regards to the hotels and the telecommunication number 2. Number 1, I'm asking for everybody again to look at the resources. Here's another, you guys opposed the Kona Vista because of the resources and a lot of other issues that people opposed or were opposing development. Here's another hotel. Again, I have my petition that I've read to you guys a few times with other developments. 546 people now have signed this petition that says, help Big Island resources and infrastructure stay safe for all who live here and visit. Again, this petition has many news articles that state our resources are, we really need to address these resources and not continue to approve more and more developments without going and really looking at addressing the landfill that's going to need to be redone. A new one's going to need to be replaced. We're actually having power outages. My home had power outages 3 times in 2 weeks. The island does not have the power to keep supplying more and more developments, as well as water issues. We have enough water, but that water is not getting into the aquifers. So to continue to approve more developments, please, I ask you to really look at the resources before you do this. With this regards to the telecommunications, the cell towers, I sent you a testimony with regards to the hazards of cell towers. And I'm wondering, has anybody really researched, I'm saying there are cell towers that we're driving right by the tops of them. And the reason is because we are on a mountain. So they put the cell tower at the base, it goes up. There's the highway. We go right by it on Palani and Queen K Highway. There's a few other ones, and I want to read you a couple articles that I've sent you. Electromagnetic fields, a hazard to your health on cell towers. It talks about in recent years, concern has increased with regards to headaches, memory problems, dizziness, depression, sleep problems. Another article, evidence of harm from cell tower radiation rising while using flawed exposure safety guidelines. Another article, basically, see electromagnetic fields, evidence of harm from cell tower radiation. So, there are proof. There is evidence of cell towers really hurting people. I actually personally have a friend who has to sleep in this ERF tent because he cannot sleep at nighttime. He actually has to now move to in the country. So Bill 194 is great for a start. Unfortunately, our Hawaii County Department has not, they just want to put cell towers everywhere. Yeah. This is the ground floor we're on right now. This is the protection of our people. This is the protection of our visitors. And to really research, to see the harms that cell towers have, done, and the research that is now starting to be out there more and more. The companies who own these have many billions of dollars to put in, and they are wanting to pay a lot of money to put these cell towers in all over. Okay, those people are not listening to the research of the harm these cell towers have caused. And because we are on a mountain, you cannot put a cell tower. Hobby Town, oh my goodness, they have a cell tower at a gas station. The cell tower goes up right across on the top. All of that radiation is hitting homes, residential homes that are not even a mile away from this gas station. Those people, have anybody gone and seen if they've gotten sick, if they've had cancer? You know, these are what we need to do before we seriously allow these cell towers to go up anywhere and everywhere. You know, we're on the ground floor to protect the island and the people. And I'm really asking you guys to please research and look at the research articles that I sent you. I only sent you a few, just a few, but there's a lot out there. There's a lot out there, you know, and we really need to start addressing our island resources and looking at the proof and the evidence of the research that has gone on. And a lot of people think that that's not true, but there are so many articles these days now. There are so many people that are coming forward with sicknesses. Again, like I said, I personally have a friend who's sick because of it. So I'm just asking you guys, please look at the resources with regards to the approval of this hotel, another development. And yet our resources have stayed the same. Traffic now is enormous. I looked at Costco.
Are you testifying now on item 1? or
This is,
item 2?
I'm sorry, I'm putting these together.
Yeah.
I'm sorry.
We're
I
just
guess I'm,
trying to follow you, really. We appreciate your research that you've done. Thank you.
thank you.
Yeah.
I appreciate you all listening and really looking at the resources and infrastructure and the protection of the cell towers.
Thank you.
Yes. Okay, aloha, Michelle Melendez, Keoka'a. So I want to talk first about the Keauhou Bay. My family's been here for 30 years. Keauhou Bay is my second home. There was my first paddle experience out there. To imagine that that bay is going to have 105 condos on it makes me ill to my stomach. I went down there when the mantas, you know, there's so much traffic even right now. There's so much. There's so much traffic down there, and to imagine.
Oh, excuse me. She's touched.
Point of order.
Okay, I'm speaking on a lot of different
We're
things.
just
So
asking a point of order. Are you testifying on item 1 right now?
item 1, and I mixed them up. So let
Okay,
me
so
let me go back.
Let's just stay on item 1. and
Okay, thank
then
you.
When you're done, then move to a different
Item 2, because I do want to talk about the cell phone towers too.
Yes. Okay.
So I do
3 minutes
second.
for each item.
Thank you so
Okay,
much.
very
Thank
good.
you so much for my sister, who is right on the money with the developers. When you look at what we have right now, so I live on the other side of the island. We lost power for 6 hours last week. And the infrastructure that we have, again, cannot.
So you're testifying on item 2 now.
Item 1 about the development for the hotel. Correct.
But you're talking about the other side of the island?
I'm just talking about the infrastructure not being stable enough to support what we have currently. And the developers that want to come in, where is the other, are we going to put in more infrastructure before they develop, this is not Waikiki. We're not Honolulu. This is not Oahu. This is Big Island. And we have Big Island living. We love us Big Island people. We love nature. We love to be out in the country. We don't want to see all these developments. There's a reason why it's Big Island. There's a reason why we all live out where we do. So I do want to go over, I definitely hope that you guys look at the infrastructure available before you approve development.
30 seconds for item 1.
Because that is the foundation of where we need to go. I've been a fitness and wellness expert for 30 years. I can tell you right now that the 5G is not
Now
safe.
you're on item 2.
Item 2,
Okay.
I think you just said I was done.
Okay.
Is not safe for the human body. It is not safe for the calcium metabolism in the human body. It does affect memory. 5G does affect memory. It has been proven. And to allow these towers with, you know, this bill that you guys want to put through, it's a good start, but we need more than that. If we really want to protect the Aina and the land and the people here in the Keiki for the future, you got to look at the evidence of the danger of these, and we need more regulations and more safety for these towers before you put them in. I mean, like I said, I've been a fitness and wellness expert for 30 years. I've seen not only the harm around these cell phone towers, but just the cell phones putting up to people's ear. We had a paddler kid brain cancer, and he always had his cell phone up to his ear, and they've actually proven that kids, because it's a radio frequency that is a two-way radio that's going into the cell, that's going into the brain. So just by the cell phones like that, now you're increasing the intensity of that, is very, very dangerous. So what I love that you guys are volunteers. I really appreciate your time. And the reason I love about that is because you have family here, and you're not getting paid. So these people putting through these bills, they are getting paid. And my question is, who's paying them to put through these 5G and these hotels into Big Island? I mean, this is dangerous stuff. And I just really am thankful that locals who are not getting paid are actually getting a chance to say yay or nay to these bills, because they're horrific and they will change Big Island forever. This is the ground floor. You are the ground floor. And so I just want to say much mahalo for your service, and that I hope you see the dangers of what this can cause to the future of this INA.
Thank you. We really appreciate all your research. Thank you. Thank you both. Are there any testifiers on Zoom that want to speak at the beginning?
Yes, Chair, there are 11 testifiers who wish to speak at the beginning.
Okay, and then they're going to swear them in there, and okay, we're ready.
Yes. Chair, the first testifier is testifying on item number 2, and that's Naomi Malamed. Naomi, can you please turn on your video?
Hi, everyone.
Hi, Naomi.
Hello.
Can you please raise your right hand? Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
I do.
Thank you. You will have 3 minutes, and I'll let you know when 30 seconds remain.
All right, thank you. Yes, thank you, Chair. Thank you, Commissioners. My name is Naomi Malamed, and I'm the Hawaii Island representative of Safe Tech Hawaii. We're a dedicated local coalition with thousands of members who are passionate about safe technology. And it's nice to see you all again today. Testifying on this agenda item, although I know it may be too late, I would like to respectfully urge the favorable recommendation of Bill 194 to the Council from the Leeward Planning, like Windward, a couple weeks ago. The Big Island requires an ordinance that achieves a delicate balance, enhancing connectivity while safeguarding the aesthetics, safety, and property values cherished by both residents and visitors. Bill 194 exemplifies this balance, in our opinion. I must admit, though, that I was surprised by the former planning director's concern about relying on the use of private consultants. I'd like to touch on this issue because if you read Bill 194, you will see within it that there is no such thing as relying upon private consultants in it. There is indeed one mention of the optional use of a single private consultant, but in no way does an application rely upon it. It's completely at the discretion of the planning director as an option. I'd like to further point out that Bill 194 does not infringe upon federal or state law. Our former council member has done an admirable job navigating the legal landscape while prioritizing community interests. In contrast, it responsibly outlines a process for measuring EMF emissions from towers, a task that the FCC does not undertake. This process is crucial, particularly to increase transparency within government and the planning department. There are many citizens who have completely lost trust in the legislative process due to lack of disclosure and information available. So measuring and posting the emissions from a cell tower would be a step in the right direction and give the public access to greater transparency. Last year, local residents associated with Safe Tech Hawaii surveyed all of the recorded antenna sites on the Big Island and a great deal of antenna sites across the state, a task that local government has never done, although they are the ones permitting such towers. The results are available on our website, and as many experts will agree, some are very alarming.
You have 30 seconds remaining.
Thank you. Lastly, as many may know, 5G is the newest buzz in commercials and the tech world. What many may not be aware of is that they require small cells. Bill 194 is hip to the latest tech trends and acknowledges this. And as opposed to the director's ordinance, there's not even a mention of small cells. They're quite different. And in conclusion, I urge the Planning Commission to consider the strengths of Bill 194 and recommend it favorably. It's a thoughtful proposal that respects both connectivity and the
Your
need.
3 minutes are up.
Thank you.
Commissioners, do you have any questions for the testifier? No, thank you so much.
Thank
Next
you.
testifier, please.
Chair, the next testifier we have is Deborah Green. Deborah, can you please turn on your video? And Deborah, is it correct that you're testifying on item 2?
Yes, ma'am.
Thank you. Please raise your right hand. Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
I do.
Thank you. You will have 3 minutes and I'll let you know when 30 seconds remain. Please state your name and the town you reside in.
Aloha, Chair and Commissioners. My name is Deborah Green. I live in El Valle. I'm testifying on item number 2. I hold a PhD in communication, and I'm the founding director of Safe Tech Hawaii, a grassroots all-volunteer coalition educating and advocating for safe technology. We're asking for a favorable recommendation for Bill 194, and I know that one of your concerns has been about federal regulations, so I want to address that. Federal law grants local jurisdictions the authority to regulate towers and antennas. In the Federal Telecommunications Act, Congress preserved local government's authority to regulate the placement, construction, and modification of wireless facilities, subject to only 5 constraints. One is you can't discriminate among providers. Bill 194 is fully compliant. Number 2, you can't prohibit personal wireless service. Bill 194 is fully compliant. Number 3, you must act on any application in a reasonable amount of time. Again, Bill 194 fully compliant. Number 4, any decision to deny an application has to be in writing with substantial evidence. Again, nothing in Bill 194 violates this. And the last thing is that you can't regulate on the basis of environmental effects of radiation, but the facilities still have to comply with FCC emission guidelines. Again, Bill 194 is fully compliant. There's nothing that suggests restricting radiation levels beyond the federal guidelines. Instead, the bill requires testing facilities to make sure they are FCC compliant, which is really important because the FCC doesn't do field testing. Planning has argued that 194 is excessive, but that's just not the case. The author of this bill did her homework. She consulted with federal, state, and county agencies and modeled the ordinance after others already adopted by local jurisdictions across the country. There's nothing out of the ordinary in Bill 194 and nothing that conflicts with federal, state, or county law. I have to admit that some of the objections to this bill are kind of strange. Please read my written testimony where I go into detail and counter each objection with facts. In your most recent meeting, the Verizon rep suggested that electrical engineers don't test wireless radiation levels. Well, anyone can test those levels. They just have to have the right instrument, which is typically a professional grade oscilloscope. And electrical engineers are the professionals trained to use that device.
You have 30
they're
seconds remaining.
Thank you. So electrical engineers are the best ones to test levels and type up a compliance report. In closing, I'll just say that with a PhD in communication and 20 years of experience in consumer wireless education, I'm very happy to stay on and answer any questions. Thank you for your kind attention.
Thank you. Commissioners, do you have any questions for the testifier? No, thank you so much. Next testifier, please.
Chair, the next testifier is Janice Paul McGlenny. Can you please turn on your video? Thank you. And you are testifying on item 1?
That's
Is that
right.
correct? Okay, please raise your right hand. Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
Yes, I do.
Thanks. You'll have 3 minutes. I'll let you know when 30 seconds remain. Please state your name and the town you reside in, and you may begin.
Aloha, commissioners. My name is Janice Paul McGlenny, and I reside in Kailua Kona. I'm speaking to item 1. To put it in the most simple terms, projects like the proposed 100-room hotel are illegal and untimely under the Kona Community Development Plan, which is an ordinance. I have to ask how the planning department dared give support for projects so clearly at odds with the law and public goals. For over a decade, it's been like talking to a wall, trying to get elected and appointed representatives, as well as development interests, to understand that the public has spoken repeatedly and consistently about their visions for their collective future and how they know that bona fide land use planning, not developer-driven growth, is key to reaching those higher sustainable and attainable goals. Many of their hopes and dreams are codified as law through the KCDP. One primary non-negotiable part of that vision and law is infrastructure concurrency. That means that supportive infrastructure for new and proposed projects must be in place or be being built before those projects are approved or started. It does not refer to roads or other infrastructure within the project's parameters that are planned or will be provided by the developer. Concurrency means that the infrastructure needs to support the entirety of the additional weight of the new project on the surrounding infrastructure and community outside the development as either in place or started. The planning for that infrastructure is meant to be community driven and planned and put in place by public agencies and fulfilled through them, not by developers. There is no possible way anyone can say with a straight face that this proposal fits within those parameters when the county and state don't have plans, no less the infrastructure in place, to support this kind of development anywhere near or emptying into this proposed project area. So please, it's your responsibility as a representative of the public and keeper of the future for all who live and visit this island for you to say no to this and any proposal that intends to use and abuse the goodwill, health, and long-term sustainability of the public, including their public trust resources and land use laws, continuing to overload insufficient infrastructure like water, roads, sewage, and wastewater treatment, all of which aren't up to legal and or acceptable standards, is a criminal act, both literally and figuratively. So mahalo for doing the Pono thing today by saying no to this proposal for the 100-room hotel. And mahalo so much for your time. I know you have a long day ahead of you.
Thank you so much. Does any of the commissioners have a question? No questions. Thank you for your testimony. Next testifier, please.
The next testifier, Chair, is Heidi White. Heidi actually is not on Zoom currently, so we'll move on to April Lee. Can you please turn on your video?
I did.
Thank
How
you.
do you do? I'm speaking on bill item 2.
April,
my
we
name
need to
is-
sign you in.
Okay.
Can you please raise your right hand? Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
I do.
Thanks. You'll have 3 minutes. I'll let you know when 30 seconds remain. Please state your name, the town you reside in, and you may begin.
My name is April Lee, and I'm in Hawaii, Big Island. I actually have physically succumbed to the effects of EMF. Why you see me on these meetings all the time, but I lost 1/3 of my hair in a week. I had a cancer show up on my arm and a cancer show up on my leg. And I was diagnosed with, this problem of these high frequencies. And I do think that thousands of studies have been done, and I've seen, and I sent you a bunch of links until I found out you can't look at links on your email, but they all show that wireless radiation really is harmful, not only to human health, but also disrupts our ecosystems. It makes it harder for birds and bees to navigate. It disrupts in migration and pollination, and even threatens marine life. So all of these things have not really been considered, and FCC hasn't updated their guidelines in 30 years. And there's a lot of scientific evidence that have come about since then. So the guidelines need to reflect the body of the scientific evidence now. And I think also why you need to be protected as volunteers for the county, plus the County of Hawaii itself. So I really think that the things that you need to focus on are these cases, like in August of 2021, the U.S. Court of Appeals for the DC Circuit ruled in favor of a landmark case against the Federal Communications Commission, challenging their decision not to review its health and safety guidelines regarding 5G wireless technology. The court ruled that the FCC failed to provide a reasoned explanation for its determination in its current guidelines, and that it didn't protect adequately by not looking at that scientific evidence. The court also found the FCC 2019 decision was arbitrary and capricious in its failure to respond to comments concerning environmental health caused by RF radiation, which I know well about. I am a general licensed ham radio operator, and most of the second tier of the ham radio operator is trying to teach you not to hurt yourself. EMS is really federally recognized a condition, and as a person who has the public, and I have to be very concerned, I've gone to classes on ADA, it is now protected under Americans with Disability Act.
You have 30 seconds left.
Oh, shoot. So I just want to let you know that there have been cases that have been won by the people that have been affected, including the causing of atrial fibrillation and other EMS syndromes. There's also a case in the matter of reassessment of the Federal Communications exposure limits, and that attorney was Scott McCullough. And on April 4th, last year, 2023, the Federal
Your 3 minutes are up.
Thank you for your testimony. Are there any questions for this testifier? Okay, thank you so much. Next testifier, please.
Yes, the next testifier is Simi McMichael. Can you please turn on your video? Simi McMichael, are you present?
Hello, can you hear me?
Yes, we can hear you. Do you have a video?
Well, I recorded myself, so I don't go over your 3 minutes. But I do send a written testimony on December 15, 12 pages, and I want to make sure all the commissioners have read it because I'll go past the 3 minutes. And that 15 pages.
Ms. Michael, we need to swear you in, please. Can you please raise your right hand? Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
Yes.
You'll have 3 minutes. I will let you know when 30 seconds remain. Please state your name, the town you reside in, and you may begin.
My name is Simi McMichael. I was born in the territory of Hawaii, and I reside in this Pua'a. I had sent a written testimony on December 15 containing 12 pages. I've written detailed about why to oppose this 100 unit and also photos that are very important. So here's my recording. So I didn't add into it. So I wanted to make sure that you have it. Territory of Hawaii. I wish to oppose you allowing the concrete slab to be used for your 100 unit project. Per AIS, there was a lava tube. Traditional lava tube bodies were buried here. Bones, iwi, contain a person's mana or spiritual essence. Chapter 6E, Historic Preservation, states it shall be unlawful for any person knowingly to take, destroy, or injure, alter any burial site. 2017, Waiheke Hotel. The state was sued by Native Hawaiian Legal Court, claiming that Pacific Beach Hotel and public agencies violated the state law by not properly surveying and monitoring a construction site where bones were found. HRS 6E 343 and 2005A AIS be completed prior to any approval or commencement of the project. Violations has already with the pouring of the concrete into the lava tube. State law is partly designed to make sure that the burial sites are identified before the sites are subjected to harm during construction or development projects. The law also sets up a process to follow if EV are discovered after construction has started. The lawsuit of the Pacific Beach Hotel, DLNR, State Historic Preservation, and the Oahu Burial Council did not administer the law properly. Native Hawaiian Legal Corp, who represented Kalei won this case in the Supreme Court. My written testimonies also stated more reasons not to proceed with this negative project, especially the water. There has been never a time where the water pumps in North Kona have fully been operating. Utility poles are a huge concern, and we are a perfect setup for another Lahaina disaster.
You have
Please
30
sit.
seconds remaining.
Okay, how coincidental was it this morning that I got a call from the water department and they said my water had spiked from 5,000 gallons to 63,000 gallons. I asked if anybody else in the area had this situation. I was told that they have every day they get calls about broken water pipes. So I'm saying your water
Your
limit,
3 minutes are up.
fine.
Thank you, Ms. McMichaels. Are there any questions for the testifier? Yes, there's one question. Commissioner, Vice Chair Pashan Duarte.
Yes, thank you. To the testifier, thank you for your testimony. And Ekalame, if I am asking this question incorrectly to the lineal descendants that may be here in the room. But my question, you had mentioned about Native Hawaiian Legal Court that had conducted some type of analysis regarding burials in a particular lava tube and or cave. Can you expand on that, please?
The lava tube in your AIS said that there was a lava tube. There's no archaeology study. They quoted that in tradition that the lava tubes were habitats, storage for the Hawaiian burials. I'm saying that they did not do the proper protocol, and they said so when they did that, and it's after the fact. I strongly feel there's bodies and EVs contain mana. They're spiritual factors. And when I see what's going to go over these slabs, I can't help but my body and my soul and my thoughts are just heavy about it. You can't go over the eras that they did in the past and then put this huge 100 units over it. It's heavy. You can't do this. And if they go through the construction and they find it, Kalei and the Native Legal Court should set precedent, because I'm warning you that I feel the spirits there. This area is special. It is of Queen Emma. And this whole Ali'i Drive is of royalty. There are 7 royal centers. It's historic. Kamakahonu is spiritual. Kahalu'u is spiritual. You're on one end of the other. It's a 6-mile spectrum. Why don't you consider the whole Ali'i Drive as historical and preserve it? Lahaina, they are going to make it a cultural. They lost everything. We didn't. We have this, we can support it and we can save it. And I really feel Ali'i Drive, like in the back days, only the chiefs, the royal priests, and their entourage could live on Ali'i Drive. This was the residential. It was the other Maka'ana that plantationers, fissioners did the agricultural. This whole land, we need to preserve it as a landscape, a cultural landscape. Why are we not honoring our...
Thank you. I think you've answered, Commissioner, Vice Chair Duarte. Has she answered your question?
Yes, thank you very much for your additional comments. Mahalo.
Thank you so much. Any other questions? No. Next testifier, please.
The next testifier we have is Cindy Freitas. Can you please turn on your video? And Ms. Freitas, you are testifying on items 1, 2, 3, and 4. Is that correct?
Correct.
Please raise your right hand. Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
Ayo.
You will have 3 minutes. You'll have 3 minutes to testify on each agenda item. If you're testifying on multiple agenda items, which you are, let us know when you finish the first item. This will allow us to reset the timer. If you don't indicate when you're done, your total speaking time will be limited to 3 minutes. Please state your name,
Okay.
the town you reside in, and you may begin.
E mele komo a he mele aloha no nā kupuna I ka au I hala. Aloha mai kako. This is for item number 1, Kona Hawaii Development LLC. I oppose, my name is Cindy Freitas, and I'm a native Hawaiian descendant of the native inhabitants of Hawaii prior to 1778, born and raised in Hawaii. I'm also a practitioner who still practices the traditional customary practices that was instilled in me by my grandparents. I'm in opposition for the following reasons. The 100-room hotel related improvements using a partially completed foundation structure on a 1.76 acre parcel situated in the special management. Testimony has been given regarding ongoing water shortage and drought. These parcels are in the Helco Power Shut-off wildfire area. Lack of currency required by the lack of putting additional strains on infrastructure, including the Kona Crawl, impact on the Kealakahe wastewater treatment plant, which is already violating the Clean Water Act by dumping it into the nearshore marine waters. The supportive testimony heard was almost exclusive given by those who already have or who will make money off of this application. But before I go any further, is anybody affiliated or have contract with this development? Please recuse yourself. If not, it's okay. We stand by the Constitution of the state of Hawaii, Article 12, Section 7. Requires the state to protect all rights, customary, traditional exercise for subsistence, cultural and religious purposes, and proposed by the A'opua tenants, who are the descendants of Native Hawaiian who inhabited the Hawaii Islands prior to 1778. And also the Supreme Court has passed H.R. S 7-1 and expanding it to include Native Hawaiian rights may extend beyond the A'opua in which a Native Hawaiian resides in, where such rights have been customary and traditional exercise in this matter. Referred to Pele Defense Fund versus Patty in 1992. Act 50 enacts the legislature of Hawaii 2000 with House Bill 2895 related to environmental impact statement proposed that there is a
Your
need
3
to
minutes are up for this
clarify
item.
that the it's up? Okay, moving on. Item number 2, County Council Bill 194. I'm in opposition for the following reasons. The tower, which there is no research on health issue that will be danger to the public health and well-being. It will cause the following issues: exposed to radiation frequencies, electronic magnet radiation between 100 kilowatts and 3 gigabytes. However, the RP energy can prepare deeper potential systematic adverse health effects of overexposure includes health exhaustion and heat strokes, and partially body exposed could result in localizing tissue damage due to hyperthermia. July 12, 2020. There was a study about living near a mobile phone base station increased the risk of developing problems like headaches, memory issue, dizziness, depression, and sleep disturbance, which could potentially apply to residents in Hawaii as well. The study highlights concerns about potential negative health effects from proximately to the cell tower. And there's another issue. If the tower will be located in areas that has significant historical properties, according to HRS 711-1107, desecration of a place of worship should not be located there if there should be any. We, the descendants, are connected to the land that we are still practicing our culture, traditional practice from Mauka to Makai. Moving on to item 3. Kulane Partners, LLC. I'm in opposition for the following reason. The applicant commissioned a report entitled Kulane Partner, LLC Plan Unit Development Kapa'akai o Ka'aina Analysis prepared by ASM affiliates in 2019, according to the report. In their statement, there are no ongoing traditional and customary Native Hawaiian rights being exercised or occurring within the subject property. This is an outrage for the culture, customary, traditional practices of the people. We, the people, are still doing our due diligence of Hawaiian rights being exercised from Mauka to Makai till today in many areas. The archaeologist report affirms in 2005 with recommends consultation in 2005, there is 66 futures, 19 sites that is, and one of them is Shifty Tag, historical era Aupua boundary wall, burial sites, blisters, trail segments, historical air closure, historical air roadway, pre-contact air habitation, and the list goes on. Again, the Constitution, Article 12, Section 7 should be protecting these things that is located on that property. And according to HRS 7-1, we can expand our traditional practice beyond our A'opua where we reside. Therefore, applicant in due respect should not rezone the lot and destroy what is still beautiful. Moving on to item number 4. Greg Gillum and Kathleen Kessel, I guess. I'm in opposition of this for the following reason. Same thing, traffic. Wildfire area with Helco power shut off. Additional strain on infrastructure, Konacraw, Yalakehe wastewater treatment plant. Another issue going on. Endangered species list. The hoary bat is one of the endangered. The second one is the Hawaiian crow. The auku'u is another one, and kolea is another one. These are native Hawaiian endangered species that frequently is in that area from 300 feet and above. So therefore, for their project, which falls in the SMA, not including everything in the ocean that is in danger, this project, I must object to this until they do further analysis, a kapa'akai analysis, to make sure none of this endangered species are gonna be affected, nor does the traditional practice. Thank you so much.
Thank you for your testimony. Are there any questions? No questions. The next testifier, please.
Chair, the next testifier is Claire Laprinzi. Can you turn on your video, please? Claire Laprinzi, are you there?
Yeah, I'm there and I'm looking for my face now. There it is. Okay.
Can you please,
Aloha.
can you please raise your right hand?
And raise my right fist and I can swear that I tell the truth. That is my hand.
Thank
Okay.
you. You'll have 3 minutes to testify on each agenda item. If you're testifying on multiple agenda items, please let us know when you finish the first item, and then we can reset the timer. If you don't
Okay.
indicate when you're done, your total speaking time will be limited to 3 minutes. Please state your
Okay.
name, the town you reside in, and you may begin.
Eau Claire Loprinzi ko noa noho ana I ka honokau iki. Let's see. I'm a kona iki. I've worked cultural traditional practices here for many, many, many years. Helped 1,500 babies being born, and mostly work with lineal descendants now with their births. So I'll go into first the first one. I'm gonna do 1, 2, 3, and 4, and I'm gonna try to look at and go a little bit with both Simi and Cindy and Janice, and most of them go into some deep things. I will try to put more stuff in there. When you talk about lava tubes, it's not just here, you know, there's lava tubes all over the world, and the EV have been in there. I work with indigenous practitioners worldwide for a long time, mostly bringing back Hanau, you know, the traditional births, but also that goes with food, and that goes with the whole thing of practicing tangible and intangible and connection to all of that. So when you look at the tubes, we know the EV have been in there and are in there. Now, I mean, even now, right now, you're looking at even in the homeless. I think it's an interesting thing, you know, that we have so many homeless, and that's where they're going to live and staying. And so it's been a place, and I know that from working down there in Ka'ulu, working on Peikoa and Ka'aina.
You're testifying on item 1 right now?
That's right. That's right.
Okay.
I'm talking about the lava tubes. Didn't I not say that?
Okay, I thought you were talking about Ka'u, I'm sorry.
No. I said in Ka'alu'u, in Ka'alu'u, you can, the lava tubes have always been a connection for people traveling, moving, EV. So they should just be respected. And I am talking about, you know, trying to bring up, you know, in other battles, and I'll wait for that for Oma's side, but that we have, that, you know, the violations to the land, when you move up these practices, and that, you know, we've got the same problem with the water, the contamination. Where are people going to get the water? And
You have
and what
30
are they
seconds left.
What are they
This-
doing with that? 1.5 million gallons are already going into Honokahau and Honokahau every single day. So our customary and traditional practices need to be upheld. Behind all the indigenous, I mean, and all the violations that you do to the land have a deep effect. So no to the development. Now I'll go into the cell towers. When you look at the health effects of babies and children, when these studies are done, they're not done on them, and they are always the ones that are most affected. They're most affected on every level, on thought, on spiritual, on physical, on mental, on the environmental effects. These, you can take the, and I'm saying these cell towers too. It's like, why are they really there? I mean, I went down to Honoapu for La Kuakoa, and how many cell towers do you see? And why are all these cell towers coming up? Is this part of war? Is that the communication part of the communication system? Because that's what our wars are, drones and sonar. Are you looking at that? Are you looking at what is affecting our children? We had to opt in or opt in to be able, or opt out to get them in our neighborhoods. But these cell towers, you are disrupting that connection.
You're testifying on ordinance 194. It's been submitted by Cindy Evans. That's agenda item number 2.
Is this cell towers? Is that one? Oh,
it's ordinance 194.
I'm
cell
sorry.
towers. Okay.
Oh, I'm sorry. I have too many notes. Okay. Well, I'll go off on that one. I mean, I'll just go with that they've got, let's go, oh, almost 3, right?
So you're on to item 3.
Well, just because you said that, now I'm looking at all my notes. And, is the development, the development on the Ooma side, that's Kulanay LLC? Is
Yes.
that 3? Okay, I'll just go to that. I'll just leave it
Okay.
for that.
Very good. Thank you.
So, okay, yeah, you're welcome. So we use these places, you know, from the mountains to the sea for customary cultural and traditional practices. And people know that they see me down at the beach and they see me with a group of very big bellied women, you know, doing prenatals, connecting. And what we're doing is we're bringing back our cultural practices. I'm bringing it back and they're bringing it back. So when you go on to Ooma side, I just was there a few days ago. It's the biggest Konani board I've ever seen. In right in the Pohaku there, right by the water, depending on how much it's at. There's Kuahus there. There's so many sacred sites. I saw a Hawaiian father who's had 4 or 5 kids that he's, you know, teaching on home, all doing the fishing practices, doing their cultural practices. And then I think about these developments and I think about, you know, we are now 6th, as high as 6 with children prostitution from this island. How are they coming in and out?
So
from
are
these
you
hotels?
testifying, are you
I'm talking
testifying
about-
of-
I'm
in
talking about that
support of
development.
of what they're doing or?
No,
opposition?
no,
Oh,
it's in opposition.
oh,
Yeah.
okay.
To stop it. Leave these places alone. When we talked about, when Cindy was just talking about, you know, these, and Simi were talking about these places have so much mana. That is what we still are connecting to. You can't take that away from us, tangible and intangible. So when you look at Ooma, and when you look at the development and all these people coming in here, first of all, besides all the other stuff, besides the feces, the lack of water, the practices, what's happening to the Hawaiian people? I mean, I'm a Kona Iki, so I can myself, I work the land. I do the Kona field system, and those areas are fine for it. But the lack of water now in Ooma, Kawaniki is right there next to it. It was the highest level of having the alkaline ponds. Look at it now. And I'm going to just go into that because I was very, very active in that, 20 years ago. I think it was around that time.
You have 30 seconds remaining.
So in that time, how many caves got busted up? How many bones did they find in? When did they bring the archaeologists in? After the fact. And that's another thing that needs to be really brought up. Was when is this shifty doe care, this whole setup, before you do any more development, get the Hawaiian organizations being Pono inside, because we know what's happening. Okay, I'm going to go on the last one, and that's the one in Puako. And when I looked at that, I just looked at that. I actually copied off the archaeological resources and the recreation. And when I listened to, well, I mean, like I said, I go around the island, I meet with women in different areas, and I do group prenatals on the beaches, because it's just a good place for them to connect and be together, and even just dig a hole in the sand and put their bellies in there and make a deeper connection. So it's a little different than what they do in the hospital, thank God. But when you look at the archaeological resources, I mean, they said that there was no survey then, no archaeological survey, and it's highly unlikely that historic sites would be found there. That's not true. 20 years ago, I went down there with a Hawaiian family. They brought me right to the birthing areas, right there. Now, when you go into Puako, you hardly I don't see any Native people, and they said that the archaeological sites that across the street, but they said that the shoreline is currently used for coastal fishing by Native Hawaiians. However, the use of the project for traditional customary rights is unknown. That is so ignorant and so disrespectful to say to our Native people. Our ways will never not be here. We will always be using them. So this parcel, you know, whether it's graded or not, we have a lot of cleanup and fix up to do. And you see that with the protections of hayhouse, the protections of birthing areas. Those areas are still there. Their mana is still there. Their EV are still there. So when I read something like this, and I think, who are these people coming over here? And you can have what? A couple $1 million to buy the place and to build it and run everybody out. And that connection, I'm going to finish with this. The connection, the basis of all law that you're supposed to uphold as a planning commission, and I'm glad you do. And if not, then that's why we're here. That's our jobs. And also, I hope that you look at the Declaration of the Indigenous Peoples'
You have
Rights.
30 seconds remaining.
And when you can look at Article, what is that, 1028, Protection of Cultural Heritage and Intellectual Property. But that book right there, I've been told by lawyers, is probably the most powerful document that's out there. So just know that we need these areas, these animals, we need everything. And please stop this development. We do not have the infrastructure and we don't need more people that are over here. We need to bring the
With 3 minutes are up.
Okay. Have a great day. Big mahalos for all you guys do.
You too.
Aloha.
And thank you. Are there any questions here for the testifier?
Chair, I don't have a
Yes.
question, but I do have a comment, if may I?
Yeah.
A comment. General comment is, thank you to the testifier who just provided her mana'o. I just wanted to make sure that she was aware. Perhaps she couldn't see that folks in the audience or many Kanaka Maoli that are present with us today. And while I appreciate the testimony that she gave and those substantive comments to advocate for cultural access and Native Hawaiian rights and the protection of them thereof, that we should be aware that Native Hawaiians can also speak for themselves while they're here in person. So mahalo, appreciate your testimony.
Yeah, and invite you to watch the rest of the presentations that are going to happen today. I think it's important. Thank you for your testimony. The next testifier, please.
Yeah, but I want to say, I wasn't speaking
No,
for them. I'm
no,
speaking for
Thank
me.
you. Thank you.
Yeah.
Yeah.
Thank you, Chair. The last testifier is Oleka Inaba, testifying on item number 3. Aloha, can you please raise your right hand? Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
I do.
Thank you. You'll have 3 minutes and I'll let you know when 30 seconds remain.
Thank you. Aloha, my name is Holeka Goro Inaba. I currently serve as chair of the Hawaii County Council, specifically representing District 8 North Kona. Testifying today to provide comments regarding the item number 3, the Kulane application. And first and foremost, I want to highlight the efforts that the applicants put forth to carefully review and take action to safeguard the cultural sites and any other archaeological sites that were discovered by creating that 14-acre parcel. That's not something you currently see typically in applications before you folks, or even when we are reviewing some applications at the council. The request for an 8-lot subdivision and those parcels that are to be created are in line with the nearby Kona Acres subdivision, larger 2-acre minimum size parcels that are being proposed. It is an infill location, and in my review, it is in line with the general plan and the Kona CDP. Their request for smaller size lots, 2 acres rather than the required 5, and slightly narrower parcels than what is allowed. I believe it's 140 feet rather than the 200 required. I feel are not requests that are out of line or too much to grant. And finally, I've personally visited the site with the applicants. I've walked to understand their vision and their commitment to doing things correctly, and I've seen the efforts that have been put forward to safeguard those cultural sites. And I'm looking forward to, an additional 8 units of housing for our local community and the continued work that their nonprofit will do to preserve the parcel that has those archaeological sites and the greater area as well. So just wanted to provide that testimony and support. Mahalo.
Thank you. Are there any questions for the Councilman Aleka Nava? No? Thank you so much. That was our last testifier then?
Yes, Chair, the remaining testifiers requested to speak when the agenda item is called.
And what agenda item are they speaking on?
We have a testifier for item 1 and for item 2.
I just wanted to know what item it was. Okay, I'm just gonna go back to a little bit of old business. It's the approval of the minutes. So the approval of November 21st, 2024, the regular meeting, and November 21st, 2024 special meeting. The minutes have been deferred to the next commission hearing in January. Okay, I just want to make that announcement. Do you guys want to take a little recess for 5 minutes or so? Yeah, so we're just going to recess very short, 5 minutes, 10 minutes, please, and then we'll come back and begin. Thank you. Okay, so we're going to reconvene. It is 2:19. Reconvening, and we're going to start with the unfinished business. And this is the introduction of agenda item number 1. We have the applicant Kona Hawaii Development LLC, PLSMA 2023-000038. This is an application for SMA Special Management Area Use Permit to develop a 100-room hotel and related improvements using a partially completed foundation structure on a 1.76 acre parcel situated in the special management area. The subject parcel is located on the Makai corner of Ali'i Drive and Kahakai Road, portion of Pu'u 3rd, Waiaha 2nd North, Kona District, Hawaii, TMK3, 7-5-018011. So today we're going to get a staff presentation.
Madam Chair, sorry to interrupt,
Yes.
but just for the record, I just want to share with the commissioners that I work for an organization and they submitted testimony on December 17th. Email testimony, I was unaware of this testimony, and I do not work with this individual closely, and any decision that I'm going to be making, this testimony will not affect my decision.
Thank you for disclosing that. I appreciate that. The other commissioners are good with this disclosure? Okay. Thank you, Commissioner Au. So the staff presentation, it's a PowerPoint by Alex Roy.
Good afternoon.
Good afternoon.
Just get myself settled. There's a lot to say. This is for Kona Hawaii Development LLC, Special Management Area Use Permit Application, so SMA Major, PL SMA 2338. As we've done for projects that have gone to contested case, and in this case mediation, I'm going to provide you guys a timeline, kind of going through that. So.
Okay.
September 14th, 2023, the application was submitted to Planning Department for review and processing. By December 14th, 2023, the first petition for standing was submitted by 2 petitioners, Grevy and Cook. December 21st, 2023, the hearing was actually canceled due to lack of quorum, as was the second hearing, January 18th. On January 31st, a third petition for standing was submitted by Ruffner. And then finally, on February 29th of 2024, the first hearing on this agenda item was heard. And at that time, the Planning Commission voted to grant standing for all 3 petitioners. So all 3 petitioners ended up going into mediation. By November 15th of 2024, the mediation had concluded, and a memorandum of agreement that was approved by all parties, including the Planning Department, was completed. We didn't add, we were asked not to, it's not really part of the record, but the applicant can speak to that if they so wish. We did add conditions that you guys should have seen that were, that came out of that, but it's not our item to share. So the applicant can speak to that. That's why you didn't get a copy.
Thank you.
So after mediation was concluded by November 16, 2024, the Ruffner and Grevy withdrew their contested case petitions. And then by November 22nd, 2024, Cook withdrew their contested case petition based on what came out of the mediation.
Mediation. Thank you.
So November 25th, 2024, the applicant notified that the item, we notified the applicant that the item will be placed on the December agenda. And then on the 12th, we concluded our addendum to the recommendation, which you should have all gotten, which added some conditions to the approval. And then here we are on December 19, 2024 for the second hearing on this agenda item today. So I'll go ahead and begin. Here's the location. We can see it's just south of Kona proper on the Makai side of Ali'i Drive. It's indicated by the red mark down there. So the applicant is currently requesting to develop a 3-story, 100-room hotel and related improvements to be operated by residents in Marriott. 91 suites with kitchenette and then 9 standard guest rooms. They will utilize the existing partially completed foundation that's located on the parcel. Additional development includes a dining area, outdoor pool, bar, the construction of a 7-foot wide sidewalk around the project area. That was confirmed by DPW. They're going to also, as part of the mediation, establish 3 parking spaces for public shoreline access. So there were none, and now they're allowing for 3 new public shoreline parking spots that'll be on the Mackay side of that property. The underground parking area will accommodate 143 parking stalls. Water is provided via an existing 12-inch water line that's dedicated by the Department of Water Supply. And then wastewater, of course, will be connected to the existing sewer line that's located on Ali'i Drive. We see the county zoning is resort, which supports this type of project without the need for rezoning. The state land use for this entire area is urban. And the LUPAG, or the general plan map, indicates the area is with a small section of coastal open space, primarily resort node. And then we see Malca as medium density urban. Here's an aerial photograph looking Mackay of the existing structure, foundation, and the subject parcel outlined in red. Here's an aerial photograph from another direction to kind of give you an idea of the structure and its relationship to nearby structures. This is the site plan that was provided to us. Now, there was an updated site plan, but I reviewed that. There wasn't much of a difference at all. But this one clearly shows the parking will be coming from the entrance to the parking will be on the south side of the property. There'll be no entrance or exit to Ali'i Drive from this. Additionally, DPW reviewed that, and that's their jurisdictional road, and they had no concerns with the use of that road as an ingress or egress to the hotel. Here's an additional site plan showing some of the room layouts. And then here's a cross-section site plan of the hotel. And then here is a 3D rendering of the proposed project at build out that was provided to us by the applicant. And you can see that how it conforms to the surrounding development. Again, another view. You can see off to the left-hand side, that little dark spot would be the entrance to the parking area below, and then this will be Ali'i Drive. There's going to be new sidewalks all the way around the property. Here's a site photo of what it looks like today, and pretty barren with the concrete structure visible from everywhere. This is a view of the underground parking entrance on the left, the gap in the foundation you see there from Kahakai Road, and this is looking towards Ali'i Drive or looking Malca. I wanted to finish with, I know there was some concerns about historic review. So I went back through just to make sure, to clarify that on May 13th, 2024, the State Historic Preservation Division made a determination that no historic properties would be affected by this project and that the permit issuance may proceed. There was a slight amendment to the archaeological assessment, and so the final assessment was submitted and completed, and the case closed by SHPD by August 24 of 2024. So at this time, SHPD has no other comments other than to be notified if something comes up during construction. So based on everything provided here, the director is recommending approval with the stated conditions, and this includes the new amended conditions that we added along with the original set of conditions for PL SMA 2023-000038.
Thank you. I see any questions? Do any of the commissioners have questions for the staff? Yes, Commissioner Noborikawa.
Thank you, Chair. Mr. Roy, in the documents that were provided for the commission, there was a mention of a variance would be needed for encroachment into the 20-foot setback and the future 10-foot right-of-way. How severe is that encroachment? You know, how many feet? Is it 1 feet, 10 feet?
If you're talking about the side yard setbacks and rear yard setbacks,
I'm assuming that's what it's talking about. I don't
Yeah,
recall specifically.
the setbacks are set by zoning, and variances for setbacks are not uncommon. And I think that because of the existing nature of the foundation, that they're requesting that setbacks.
Okay, so is
the
it like
variance.
a foot? Because it sounded like the foundation was built and then a survey was done later, somewhere along the lines when the property changed hands and was found that there was some encroachment. Is
Yeah,
it like,
encroachment into the setbacks,
Right.
not across the property
Right,
boundary.
right.
But I don't know how far in, and maybe the applicant can speak to that when they come up.
okay,
Yeah.
okay. Thank
But
you.
yeah, it does not cross the property line. I just want to make
Right,
that very
right.
clear.
Just
Yeah.
into the setback.
Into the setback of the set by zoning, yes.
And when exactly was that foundation built?
That I'm not sure, sorry.
Okay, so it looked like somewhere between 2008 and 2010, somewhere in there.
Yeah, I believe it's over 10 years.
Okay. Is there, and I know this is not a zoning thing, but just curious to find out, is there going to be any type of inspection required to make sure that concrete slab that sat for that long is going to be still functional?
Yes, I mean, for sure. DPW during when they apply for building, if approved, when they apply for building permits, they would definitely have to get a foundation certification through the Department of Public Works, as is for any development that would occur. I don't think they'll stand on the reviews that were done 10 or 20 years ago. They'd have to review, but that would all be under Department of Public Works during the building permit phase.
Thank you.
Commissioner
further questions.
Al?
Thank you, Madam Chair. Thank you, Mr. Roy, for that presentation. I know the applicant's going to elaborate on it, but you did make mention that out of the mediation, one thing came out of it that you're aware of, the 3 public parking spaces. Do you want to share anything with us as far as the mediation, or should we just let the applicant take it?
No, I'll go through just for everybody else. You know, we emphasize that the applicant needs to comply with all current laws and codes, including those relative to community noise control, which is a big thing for the petitioners and other folks. So we wanted to make that clear. Typically, we put a very generalized condition that the applicant must follow all rules, but here we expanded to make sure that it's very specific to noise control, because that was an issue. That the construction operation is based on what we hear today, not based on what was done in the past. So that's another condition. And then based off of the memorandum of agreement that was agreed upon by all parties. That the applicant will establish 3 new free public parking spaces for Shoreline in the SMA. That is very important. That's something that we really try to get anytime, whether it be access or parking or improved access. And then last, I think, which is important, the applicant will develop an emergency response plan for the proposed hotel in conjunction with civil defense and the fire department. And the plan needs to cover shelter in place, evacuation, and other, and routes in the event of any number of potential disasters. They will publish, post, and provide guests and employees with a copy of that evacuation plan, and consistent with recommendations made by Civil Defense. So that is what came out of memorandum of agreement that could be included in the SMA. Now, there were other items that really had no relevance to the SMA, say interior things, other things that just have no relevance. So, but we added everything that had relevance to the SMA as a new condition, based on that memorandum of agreement that was approved upon by all parties.
Thank you. Commissioner Rodriguez.
Yes, my question is, there's concerns about the infrastructure. Is the water and sewer up to code to take on this extra burden?
The sewer for sure. Now, there were some issues with the amount of water possibly, but when they're building a large structure like this, they're going to have to do water calculations, and there'll be the Department of Water Supply will end up having to kind of allocate the appropriate amount of water. But because there's nothing going on right now, it was hard to do those calculations. So estimates have only been submitted.
Right.
But according to them, there is water and there is sewer available for this type of structure at that site. Yes.
Thank you.
Thank you. Yes, Vice Chair Paishon.
Thank you, Chair. Yes, question to Mr. Roy, following up on Commissioner L's question regarding parking. Right, two questions. First, why 3? Is there a calculation for determining the number of stalls? And then the second question is, who will bear the cost of maintenance for these parking stalls?
I wasn't part of the mediation, so I'm not sure if the director or we can leave the applicant to ask that. It might be a space issue. If you look on the diagram that I provided to you in the addendum, there wasn't a lot of space. And then, the idea is not to crowd those roads, to keep cars off of them, to keep them open. But the applicant might have to speak to why 3 was the magic number. And I believe that they are responsible because it'll be on their parcel. To maintain those parking spots and place signage indicating that they're for public shoreline access.
Yes.
Thank you, Chair.
Director Darrow.
So that's correct, what Mr. Roy said there. Through mediation, it wasn't, it was just that was agreed upon 3 stalls. It is required for the applicant to provide those and to maintain them, and to make sure that they're available for the public parking. The other questions before, I don't think that the applicant stated exactly how much they need in the variance for the setback. They've just said that there were encroachments in the 20-foot front yard setback, so they need to submit it after the fact. They may have already done that. I'm not sure. We'll have to see if that's been submitted. Lastly, there's references that the structure was built in 2007, 2008. Thank you. I do have one other item to bring up. The applicant's representative did email us while we were doing our presentation and mentioned that, let me just get this here. Exhibit number 3 within our background, within our amended addendum, needs to be changed to reflect the most current ADA ramp. So what we will do is we will send that to the commissioners shortly. It was sent to us in an email. We may have had the wrong updated Exhibit 3. So they provided that with us and we'll provide it with you. It shows the agreed upon ADA ramp. And that's all it is. Yes. And again, we'll send those to you shortly via email and then make them available. Thank you.
Thank you. So with no further questions, we're going to do the applicant's presentation then. So will the applicant and their representatives please come forward? So we're going to swear you in today to tell the truth in front of the Leeward Planning Commission.
Yes, I do.
Okay. And you don't turn your mics on. You'll speak directly into it. You're going to state your name and the town you reside in, and then whom you represent.
Sure.
And my only question is, as you're going through this, is that you've received the background and the recommendation reports from the planning department, and that you agree with the recommendation, including the proposed conditions.
Thank you very much, Madam Chair, members of the commission. For the record, my name is Sidney Fuki. I'm a planning consultant, and I'm here assisting the applicant. Seated to my right is my residence address is in Hilo, Hawaii.
Yes.
Seated to my right is BJ Patel. He's vice president of the entity. I'll also like to acknowledge the presence of Randy Vitusik. He's the attorney that assisted in the mediation process. He's seated in the back, and we have Mr. Dwight Bailey. He's the architect. He's on Zoom. So if there are any design-related questions that the commissioners may have, he's available.
Thank you.
To answer your question about the staff's background report and recommendation and the addendum, yes, we've had a chance to review them, and it's totally acceptable. It's very comprehensive. I'd like to, perhaps like rather than going, I was thinking like, should I just answer directly the questions that were raised by different commissioners, or
Yes.
go through what I had prepared? And then I kind of remembered what my wife told me as she pecked me on my cheek this morning. And she said that, remember the kiss, and that is keep it simple. And so I said, okay, fine. So anyway, what I'd like to do is kind of like, because it's been a while, I'd like to kind of like share with the commissioners, who the applicant is, what their general proposed project is, but I'll skip the proposed project because I think your staff provided that quite comprehensively, how we got here, and try to respond to some of the comments that were raised by the public as well as the commission.
Thank you.
So briefly, Baywood Resorts, they develop and manage over 120 Hilton and Marriott type of hotel products. This is their first entry into the state of Hawaii. So what they did as a result of this is trying to put their foot in the hot water. They had to do all of the required due diligence. They didn't want to go and accept a property that had to go through zone change, so on and so forth. So they sought entitled properties. And they did, during the course of their due diligence, they saw that this property was already zoned since 1967. It was ideal location, given in the Kailua area, because Marriott has one anchor on the northern anchor, the King Kamehameha Hotel. This property actually would represent the other anchor of whole Kailua Village. The last anchor right now, the current anchor is actually the former Kona Hilton Hotel, but this is the property that's right next door. So they evaluated the location, they looked at the infrastructure, and based on all of whatever their evaluation showed that there was no archaeological issues, there was adequate infrastructure. And then they saw this, kind of eyesore. So what they felt like would be a good idea to just kind of help eliminate some of these visual eyesores. They're like homelessness issue, litter, so on and so forth. So they thought that since it's entitled, this would probably be the best type of hotel product that they would want to have developed. So that's how they decided to proceed with a project of this nature. Now, as I mentioned earlier, the property is already general plan, in the resort area. It's been zoned resort for time since 1967. So the question then is why are we here? Because you already have it zoned, but we're here only because the property falls in the special management area. Because it falls in the special management area, you still need to go through this process that requires the commission to make an evaluation on whether the project, the proposed project, meets the requirements for, meets the guideline and the criteria for SMA. And if it doesn't, then what kind of mitigations can be put forth? So that's why we're here. So they submitted an application in September of 2023. We're supposed to have a hearing, as Commissioner remember, in December, January, February, but for different reason, the lack of quorum, the hearing didn't occur. And finally, at the ending part of February of this year, we had a first hearing. There was a request by 3 individuals for a contested case hearing. We had to go through a contested case hearing, and the process calls for mediation. So over the last 6-8 months, we've gone through a mediation process, and we're, as a result of that mediation, and this is my second effort on mediation, and I gotta admit, like, the rules are good in a sense that, we had, I think in January, February, the same commission, we had this application in North Kohala. We had to go through mediation, and then we resolved this. And so likewise over here, it took a while, but we did go through a mediation, and we arrived at where we are right now. And so now in terms of, like, first of all, trying to understand that the use is already permitted. So how does it relate to the SMA kind of considerations? So one of them, the SMA calls for, like, is public access. So it's like, okay, now we looked at the area. They already, this is not a coastal property as you saw on the map. It's kind of like adjacent to Ali Drive. It's within the SMA, but it's not a coastal property. You have a number of structures. There's Makai of this building, this proposed building. But, so we say, like, okay, there's an existing public access on the Kona Reef property. People use Kahakai Road from Ali Drive to walk down to that area. So you have access to the shoreline. Now, so what they decided to do is said, okay, we will improve Kahakai Road on all that section that rims the property. So we'll put in a pedestrian path in that area, even to the point where it has to encroach within the property. So it's not going to be within the public right-of-way, because the public right-of-way is relatively narrow. It's about 30 or 40 feet. Normally you'd want to have 50 or 60 feet, but in this case here, it's not. So they're going to make a pedestrian improvements, within that kind of straddles the public right-of-way and also within his property that rims the entire property in that area. So along the way, what they're saying is that, as we were going through discussions with the community and hearing public access issue, so like, well, okay, you already have the access, so maybe we will provide an additional area for public parking within this public area rather than within the hotel itself, because it can create some kind of ill feeling that you have to go into the hotel to get this public access parking. So the idea is to have this available area be set aside for public parking. And it just so happened that there is an area on the Makai side of the proposed project that's enough space for 3 public access stalls, but they're going to have to be on the applicant's property. So the applicant, to answer that, I think one of the commissioner's question, it becomes their obligation to maintain, to assume some measure of liability and all that stuff. So that's what they're going to do. The other thing is, like, the concern was to make sure that the guests of the hotel, they don't go directly on the Makai side of Kahakai. They wanted to force them to go on the southern end of Kahakai Road to get that, use that legitimate where the public normally goes, to use that portion as a public access. So what they did is, by design, they specifically do not have, like, any access point for the hotel guests to get down on the Makai side of Kahakai Road. And however, although there is an access for ADA and all that, that's designed only in the case of emergency and employee only. So it's not designed to allow for the general hotel users to get access to Kahakai Road, on the Makai side. They have to come from the southern end. There was this, I guess maybe I can, relate to the design issue on the variance question. We did have to, acknowledge that the existing foundation, what they're doing is they're using the existing foundation, and that foundation was constructed in the year 2007 and 2008. So the normal setback because Kahakai Road is a government road, the normal setback from all government road is 20 feet. But when that structure, the foundation was constructed, it was constructed about like 8 to 10 feet from the property line. So the variance to answer your question would have to be, as opposed to a 20-foot setback, would have to be like an 8-foot setback, 8 or 10 feet. So that's how the variance is needed. Now, as I mentioned earlier, you already have the foundation. So what they're going to do is utilize the existing foundation and then build up on it. So when they do that, however, they have the building slightly recessed so that as you, it's going to be slightly recessed. So it's not going to be like, 12 feet all the way from the property line. It's going to be slightly recessed. But nevertheless, there is a need for the variance to allow for the retention of this the foundation that was already constructed in that area. Related to that, because it's been dated, yes, when they go in for a building permit, they have to provide structural analysis to show that the existing foundation is stable enough to accommodate the structure. And if not, then what other accommodations are being made to assure the stability? So those things all need to be addressed. We needed to acknowledge that a variance was required because we wanted to be totally transparent and say like, hey, look, if we didn't acknowledge that a variance is going to be required and later on we apply for a variance and then you say, oh, we didn't know a variance was required, but so we had to be totally transparent and acknowledge that a variance was required. So what if the commission approves the project, it's going to be as is, it's going to be approving the idea that we're going to be applying for a variance to allow the retention of the existing foundation. So, and this kind of like segues a little bit into the other issue about the archaeological. When the project was first approved for an SMA in 1998 or the late 1990s, and then subsequently there were like time extensions. During the course of all of that, there was never any specific archaeological assessment done of the property. And the reason why was that prior to the foundation being established, there used to be a mini golf in that area. It was all paved and all that. So then that's the reason why the initial one is like, no, okay, it was fully disturbed, so you don't need to have an archaeological assessment. Then the foundation was constructed. So the foundation was constructed, and during the conjunction with the time extension, again, no archaeological report was prepared. SHPT, the State Historic Preservation Division, said like, well, basically, well, the area is already improved. So all we need to do is any subsequent work, we're going to ask for subsequent review, opportunity for review. So the applicant, we said like, no, why don't we be proactive and say, since that question is out there, just do a study. So the archaeological assessment was done. It was done, it was reviewed by SHPT, and SHPT said, we concur. There's no historic site or properties being affected. And that was like, as the staff mentioned, that all occurred like this year, maybe May or sometime May or June of this year. So that's already contained in your report as far as the approved archaeological assessment. There is this issue about the cave, but I can't really speak for that, except that if you see the photos that the staff had provided, it's already all sealed. So, covered with concrete. So this is the area that the developer intends to do. Use that existing foundation. It's not going to be creating new foundation. If anything, any new items, new foundational aspect might be as it relates to help stabilize what's already been there. So in addition to that, if your condition 17 already has, as the staff is recommending to say like, in the unlikely event, there's something that may be archaeologically or culturally of significance, and you got to stop and you got to let us know. So that's your standard thing, and the applicant intends to respect that. There was this issue about like, what about sea level rising? What about flooding and all that stuff? Well, the fact of the matter is that the FEMA map is already Zone X, so the area is not subject to flooding. and it's not adjacent to the shoreline. So you don't have the sea level rising or this erosion kind of concern. It's roughly about 200 feet away from the active shoreline. There were also concerns about like view plane. True, like, we can feel like, like anybody, if you have a home and somebody comes, your neighbor, wants to build on the vacant lot, build a residence 2 or 3 story high, it's going to affect your view. There's no question about it. However, as it relates to the SMA, you need to look at like what the SMA calls for. The SMA says that view plane is important from public highway. And the public highway over here is Ali Drive. So you look at Ali Drive, that's true. But today, if you drive on Ali Drive, you can't really see the initial waters. And the reason why is they have development below that. There's existing condominium in that area, so you can't really see. But nevertheless, out of an appreciation of the design aspect, coming on Ali Drive, rather than creating like a monolithic building as was the original plan, what they planned to do was create like a porte cochere. So you can at least have some recess, some kind of like an open feeling. And they're also going to make like sidewalk pedestrian improvement along Ali Drive to make it more inviting. To where we don't have some of the, the architectural design, the renderings, but they were all in the application itself that shows like what the kind of flavor that the design is intended to do. There was question about like traffic, emergency evacuation. I won't go into, a significant judicial decision, but your counsel can probably talk to you about that if you have. It's called topless. Basically, the decision by the courts was just that, traffic is not a legitimate issue on an SMA, except as it specifically relates to SMA kind of issues. I know people talked about like, looking at traffic like as though this is like a rezoning issue, but this is not a rezoning issue. This is an SMA. So, but nevertheless, I think, just generally talking about like the traffic aspect, there are some mitigations that they're being proposed. As I mentioned earlier, mitigation is that to make all of the pedestrian improvements along Kahakai and Ali Drive fronting the property. And most significantly, which is kind of unprecedented, is that the new condition 12 relating to an emergency evacuation plan is something that we had suggested during the course of our response to public comments about like emergency evacuation. And this is kind of like finally captured in the staff's proposed condition number 12, which basically says you have to prepare an emergency evacuation plan, only for your hotel, but actually like, from my perspective, I think it would be better to have a regional evacuation plan, but that's beyond the applicant. But specifically as it relates to the applicant, he has a responsibility to kind of coordinate with civil defense, fire department, police, and then come up with a plan that's got to be vetted and approved by civil defense and the county. And then that's got to be implemented. There was issue about like, maybe Commissioner Rodriguez had asked a question about water availability. Yes, there is water. We had submitted, the water department had committed itself to say, yes, the project is allocated 22 gallons per day, 22,000 gallons per day. So they had to work within that limitation. They had their engineers kind of review it and say that, yes, your water use based on your project right now is about 21,000 gallons. At the end of the day, the engineers, their engineers' opinion doesn't count. What counts is the Department of Water Supply. So the condition right now requires that the engineer, their engineer, submit a report to Water Department to say like, this is their estimate, and Water Department has to concur that your estimate is this, is that. And if it's not, then they're going to have to scale back the project. If in the unlikely event that they utilize more water than this current allocation, the Department of Water Supply already has regulations that allow for termination or cessation or some kind of measures to kind of control so that you don't exceed their allocation. It's no different than if you're a farmer and then, your allocation is only 600 gallons a day and what you use about 1,800 gallons a day. Water Department may come back and tell you that you're using more than your allocation or not, but they do have the ability. Whether they exercise it is another question. On the wastewater question, we already have a comment from the Department of Environmental Management saying that, yes, you can connect to our system and you are required to connect to the system. Now, on a non-SMA type of issue, noise, said, yes, we agree that, like when you have construction, you're going to have noise, it's going to be a nuisance. And so what the staff has proposed in terms of an additional requirement in their addendum is totally acceptable and understandable. The last comment, I think public comment, was about the labor law and, a wage requirement, and the applicant clearly understands that they have to abide by whatever laws that the state of Hawaii has relative to wage, construction requirements, so on and so forth. But as I mentioned earlier, if the project goes through and they're going to do the project, this is their first entry into the state of Hawaii. So they've already made a commitment to say that because this is the first time we're going to come here, I'm not going to be crazy and not consult with people. And the people I'm going to consult with, obviously are people who are already in the industry, whether it's the labor organizations or other contractors, so that they can have a better feel as far as what's best for them to do. So in summary, it was a long summary, but anyway,
Remember that kiss.
your staff has already vetted the application relative to the SMA criteria. The use is permitted. We feel like the project meets the SMA requirements, with these mitigations, and we respectfully request you guys' approval.
Thank you.
Thank you.
Thank you. Did you want to say something?
I just wanted to say thanks to Sid for keeping it simple. So.
Well, I really appreciated that he went into the depth that you did and that you covered a lot of things and in showing us, and looking at an SMA, that's just part of the process that this is going to have to incur later on if this goes through. So are there any questions from the commissioners? Oh, yes, Commissioner Naborikawa.
Thank you, Mr. Fouquet. So I noticed in the plans that were submitted as part of the background report that on the third floor, there's a dining room and a food preparation area. Is this like a commercial part of the building, or is this just available for people renting those rooms to do their food prep there?
Yeah, if you've been to the not the top end Marriott or the Hilton, you find those breakfast area primarily for the guests. That's what it's intended to be, correct?
Sorry, Commissioner, were you referring to inside of the rooms, or was it a public area?
On the third floor, it says dining room and food preparation area, and there's also an office next to it.
So Sid is correct. Yes, it's just breakfast prep, things like that.
Okay, so just a small breakfast prep area. But it's run by the Marriott. Is that, okay. Is going to require a lot of, delivery trucks and would they have access through the basement parking? Or would they have to be parked on Kahakai to make their deliveries?
No, they are three areas for delivery trucks too, and that's required per code, by the zoning code, so.
Again, and those will not be blocking Kahakai, because I know that was one of the concerns that I was reading in the testimony, that big trucks and things like that may
The
block
loading zones
Kahakai.
are all going to be on the property.
Okay,
Yep.
Thank you.
Commissioner Rodriguez.
Yes, I have a question and I have a concern about using the existing foundation. I served in the Army Corps of Engineers, and I just have a concern. It's an old foundation. I'm explain why, sometimes when you get steel and you put concrete around it, you get moisture in it. It expands, it rusts and expands, it blows up. So that's my concern, is using it's going to be almost a 20-year foundation. So, and I know it's going to get reviewed, but that's my concern.
Thank you. Yes.
Well, a quick question for you
Commissioner
guys.
Kinoha.
You kind of answered all the questions I was going to ask, just touching on everything that you went through, Sid. Thank you for that. What do you envisage, everything going well? How long from groundbreaking to completion do you see this project taking, such as us not having something as an eyesore sitting there moving forward, as if this is granted today?
Yeah. Yes, Commissioner, I think that once we get through the SMA, hopefully today, there's obviously a variance that we publicly stated would happen. Site submittal approval. We think that we're gonna wrap that up probably by May of next year, which then will allow us to submit plans. We'll have back and forth through the city planners, of course. We expect to start construction sometime in 2026.
And what would that timeline be for completion?
I think it's probably a 24-month build out.
Thank you.
Yep.
Vice Chair Paishandor.
Yes, thank you. I also have a timeline question. I have a couple questions. The first is a timeline question. You know, we're here as volunteer members of the commission to serve the best interests of our county. My question is, what year do you estimate this project to be profitable? Is my first question. And then related to that question is what is the estimated economic impact to, especially for residents here on Moko Keawe?
Madam Vice Chair, Commissioner, thanks for that question. The brands that we partner with, Hilton, Marriott, this particular project being a Residence Inn by Marriott, we've had a lot of experience with this particular brand. Usually the ramp up period is what we call it, is really within 90 to 120 days. Of the occupancies in Hawaii are pretty healthy. So maybe that time for ramp up is even shorter. We expect that the hotel will be at a good occupancy pretty quickly. As far as impact to the community, you know, we wanted to go through this process to make sure we're doing everything right. Like Sid alluded to earlier on, is that this is our first project in Hawaii. We didn't want to step on any toes. We want to do the things the right way. You know, there's going to be lots of jobs created through this through the hotel. There'll be a tax base. Just we're here to be in the community, and if there's an opportunity in the future for us to grow our footprint, we'd love to do that.
Thank you. As a follow-up, may I just have a quick follow-up?
Yes.
Thank you very much. I appreciate those responses, and I guess I'm still not grasping to the number of jobs that will be created during construction period and then during operation period. The reason why I bring this up is that we've had some really great proposals from applicants that have committed, right? It's a commitment. They will commit to working with or contracting with local vendors, for example, making sure that jobs are created so that residents here can employ them. And so I'm just asking, what is your commitment or your desire to support the local economy?
Okay, I think I now understand your question a little bit clearer. We do not we will be using all local labor, either on the island or the islands. We don't intend to bring anything from the mainland. It's probably more expensive to do that anyway. As far as the exact numbers, I don't think we've calculated that yet, but we could certainly submit that to you as an overall plan in the future. So, you know, that's kind of where we stand. We're here to be supporting of the local community, the local labor force. We're not going to bring anything in from the mainland.
Thank you.
Is there another question?
Could I ask a question to the planning director? You know, another concern I have is the underground garage. Is that common down on Lee Drive, being so close to the shore?
Yes.
If 100 vehicle parking garage is common?
Yes, down that, you know, if it's safe and common.
Yes, I mean, it's not, I mean, the hotels that are along Elite Drive, some of them, most of them have outdoor parking, right? They don't have underground. We've had just recently Meissen that proposed the underground parking. It wasn't for that many parking stalls, but again, a lot of that has to do with the outcome of mediation, right? Is it's an agreement sometimes to lower a story, right? For visual impacts. The requirements placed on the applicant are to make sure that whatever happens on the ground regarding stormwater drainage, that they take care of that on site, regardless if it's underground parking or if it's outside parking, whatever that is. They will be required to take care of that. Just for the record, there is another structure just makai of this structure. This isn't right on the shoreline, but it's not that it's not close, but there is an existing, I believe it's a condominium that's just makai of this structure. Okay, thank you.
Okay. All right, are there any other questions? So thank you for, well, there may be more, but right now, thank you. So we're going to go to the in-person testifiers for this. We have two, yes, you can take your seats. We have two people to testify. And before we start, I just want to say again that you have 3 minutes to testify on this agenda item and that you do so with respect to everybody here. We have two people. We have a Pete Van. Will you please come forward? Pete Van, are you here? And Lama Ku Mikahala Roy, please come forward and sit down here. Both of you, please take a seat. I'm going to swear you in. And you will each have 3 minutes to testify. Mr. Van, you will speak first. I'm going to ask you to raise your right hand, both of you to raise your right hand, and to swear to tell the truth today in front of the Leeward Planning Commission.
Yes.
Yes, great. Madame Roy, will you please just press the button there so that the light comes on? Very good. Okay, very good. Okay, so Pete, you have just state your name and where you reside, and you have 3 minutes.
My name is Pete Van, and I live at the Kona Reef right now for 29 years. And I want to just bring up some topics about the hotel that no one else touched so far. Okay?
Yes, please do. Appreciate it.
The Royal Kona Resort, you pay $300 a night, but you have to pay another $30 to park there. People don't park, they park in the street then. They save $30. Now, we just want to make sure that the Marriott does not do the same thing. They have to have their price of the hotel room and car together for parking. Otherwise, they'll be parking on the street too. Okay, the new Marriott should have an observation deck on the roof. So the people there can watch the sunset and don't bother people on the shoreline, stuff like that. Also would be really nice if they had a restaurant on top there. That would really help because nobody else has a rooftop restaurant. And I'm just a little concerned about traffic on Elite Drive to turn into the new Marriott. Because I counted the cars from Uncle Billy's three-way stop to the new Marriott. I counted 103 cars stopped right there, backed up. I want to find out how are they going to solve the problem. Traffic lights are too expensive. Stop signs, locals who drive in a POS, they just blow right through them. And speed bumps, rent-a-cars, they speed up for those. Give them a little lift. I don't know how they're going to control that traffic right on the corner. Maybe a mini roundabout. That's the only thing I can think of. That's what I really come here to find out. 25 years ago, the Leahy Kona, the Leahy Cove was built. And before they built it, they had us say, we're gonna make a restroom, parking lot, and showers for Hanos Beach, in which they did. And I haven't heard anything what the Marriott's gonna give back to the community so far. So what I like to see it done over by the Laverne's restaurant, south of there, between Lee and Kalakini Drive, have the county purchase that land, make a parking lot of it, and have the Marriott's pay for that parking lot. Not for the land, just make it, so they make the parking lot at, and free parking and not hotel parking. Free parking, that's what we need down there. The 100-room hotel is way too big. Having 100 cars, in theory, plus the staff going on Lee Drive. That's too much. 50 rooms, hey, that's great. That's what I would put out there. Put deluxe rooms there, something different. Now they're just putting small ones. And that's about all. One thing I like to address has nothing to do with this. The Kona trolley, put GPS on it.
Thank you. Thank you. If you're done testifying the agenda item, then thank you. Okay. You can turn your speaker off now.
Okay.
Okay, thank you. Yes, please state your name, where you reside. You have 3 minutes.
Aloha. By Most High God, I am Her Royal Majesty Ka'io Mana Ulau Kalaniki e ki Eloa Kiahi Ena Mau o Kalaulani. Lamaku Mikahala Roy, Kahuna Nui Kahu of Ahu Ena Heiau. This message is from the ancestors of Oiwi who uphold the highest light of Akua, Mana Mana Loa, Most High God, at Ahu Ena Heiau Kamakohonu. Greetings, members. On the matter of the application of Kona Hawaii Development LLC, discover the attached letter written and conveyed on March 3rd, 2021 to the Hawaii State Legislature by my representative in Hawaii and on Earth. The information found here holds even greater importance today. You receive communication here from the highest lineages of Oiwi, the first people of Hawaii and the Pacific who serve Most High God on earth. Our voices are heard through the oracle, the Lana Nu'umamau of the first restored spiritual temple, Heiau, created by mankind on earth. The Heiau is Ahu'ena Heiau, translated as burning altar, located at Kamakahona, the first capital of the Kingdom of Hawaii, unified by Kamehameha the Great. Kamakahonu now includes the new sacred expanse of 40 miles of land from North Kona, from Kaloko Honokohau to Honaunau, South Kona. The new sacred expanse of Kamakohonu now carries the expanded mana of Ahu'ena Heiau. These lands are also known as Pu'uokaluokalani, the heart of the second heaven. All Oiwi in Hawaii and throughout the world are lineal descendants of Pu'uokaluokalani. By these designations, these kauoha, sacred commands and proclamations of Most High God, your offices of the Leeward Planning Commission, City and County of Hawaii, and the offices of all counties in Hawaii, along with all offices of the state of Hawaii and the U.S., are now reminded that you illegally occupy the Kingdom of Hawaii. The Kingdom of Hawaii, restored by His Royal Majesty, King Ali'inui Mo'i Edmund K. Paki Silva II at Ahu'ena Heiau, Kamakohonu, is the ancient and true first kingdom of Akua, Most High God, and first temple of earth ever created created by Oiwi for all mankind. This sacred testimony is verified in the spiritual records maintained in the sacred oral history honored and treasured in the sacred lineages of Oiwi. These are held in heaven on earth at Halau No'eo Kahele the house of wisdom of the mountain roaming chief at Pu'okalua Kalani and first residence of the capital of the kingdom of Hawaii. O Kapono ki Hanaia Iho Mai Kalani. As righteousness prevails, heaven descends. The Olelo No'eo by our people.
Thank you very much. Mahalo. Any questions for the testifiers? No, okay. Oh. Do we have anybody on Zoom?
Chair, we do have one testifier on Zoom,
Can you please
Jana Cook.
swear them in?
Jana, can you please raise your right hand? Do you swear or affirm to tell the truth on this matter now before the Leeward Planning Commission?
I do.
Thanks. You'll have 3 minutes and I'll let you know when 30 seconds remain. Please state your name, the town you reside in, and you may begin.
Thank you. My name is Janet Cook. I reside in the city of Mineola in Texas, but I own property there on the Big Island at Halikonakai, which is that 39-unit condominium complex directly makai of the development where our parking is underneath the building. And I want to take just a moment to say thank you to your support staff. Last year after the meeting in February, I made some suggestions about how to improve the Zoom experience. They accepted those suggestions, they improved on them, and today's experience has been much more pleasant. What I want to bring to your attention is the applicants. In their initial application, and these are the words of Sidney Fouquet, it was purported to be a 100-unit hotel when there were actually 151 units. I was one of the contested case people that was granted standing, and this was amended through the mediation process that they have reduced this to just 100 doors, but there are still 51 two-bedroom suites, and it's a very large hotel by square footage. And also one of my main concerns was that Exhibit 3 that was, whether purposely or accidentally, we'll give the benefit of the doubt, was submitted to you for review was incorrect. It was supposed to, it's beyond me how that happened. There's supposed to be doors at the top and doors at the bottom to prevent public access and to prevent any other unauthorized access, and they're just omitted on that. And when the applicant has been this disingenuous on other things, I would hope you will consider and give the sniff test to everything else that he is putting forward to you. And I'll call your attention to that water report. They want to use the existing 12-inch water meter. They acknowledged, Sidney Fouquet acknowledged in his report, there's no additional water meter available. They can't get more water. And in my opinion, they reverse engineered their water report to come up with 344 people. They do this by saying that of these 51 two-bedroom suites, they
You
are
have
all
30 seconds remaining.
with a 4-person maximum, and only 5 of those have a king and 2 queens with a 6-person maximum. There's nothing, and it is upon you to put those conditions on that actually limit the occupancy of that hotel, protect the natural resources, protect the infrastructure, and put in something that they are going to have to abide by going forward. And I thank you for your time.
Thank you for your testimony. Are there any questions? No. So do we have the applicant to respond to any of the testifiers' concerns? Mr. Fouquet.
Well, since I've used maybe more than my 3 minutes of allocation, really nothing more. I think we've kind of answered it. I kind of want to reemphasize I think Commissioners, Rodriguez issue about the stability of the structure, that has to be vetted, clearly vetted, because it's like when you have like an S-built, coming with a building permit, you have to provide all the documentation with engineering reports, so on and so forth. So this will be the same. So, I'm sure that the developer wouldn't want to assume any liability by utilizing a structure that's been deemed not unsafe. Related to that is that the, my time's up.
No, we don't have a time.
Oh, yeah, but anyway, like, the original plan already calls for the parking to be subterranean, so that's what they're planning to do. So all of those structural things would have to be evaluated. And as I mentioned at the end, this is their first time around the block, hopefully around, it won't be the last, but then as the first, they would like to work very closely with the island community, island building construction industry, the labor organizations, just to make sure that they're in step, because, if this is successful, this will probably not be their last project.
Thank you.
Madam Chair, I have a question.
Yes.
So through the contested cases, just to clarify, there were memorandum of agreement signs, sections A and B, correct? Okay, thank you.
Okay. Is this a
Could I ask
question?
a question? If I understood right, you said, you're allowed 1,000 gallons of water per day. Is that correct?
The allocation, as I mentioned, I think it was 22,000 gallons a day. That's the allocation that the water department has committed for the project. And at the end of the day, they have to submit the report. Water department has to accept it. If there's abuse to it, then there are ways that they can terminate the use. That kind of reminds me, I think the question, the additional comment about like, well, you have 100, but you're going to use 150. Two things going to happen. First of all, I think the planning department would have to review the plans just to make sure that you have like 100 units and not 150 or 101. So that's clear. So they have a secondary line of defense. More critically, however, is that if there is abuse, in fact, they have like 101, 102, this matter would be a violation of the SMA permit. And so I would hate to think what happens if you violate the terms of the permit. You have to come in for an amendment, or let alone be subject to having it revoked.
Thank you.
Yeah, to me, what do you plan to, use, 'cause 1,000 gallons of water doesn't seem like a lot of water. What do you plan to, how are you gonna supplement that?
Can you repeat that? I apologize. I thought it was going to you, sorry. Commissioner.
My understanding that, you're allowed 1,000 gallons of water per day for the whole unit.
I believe
You know-
that question was already answered. It's not 1,000 gallons a day.
22,000.
It's 22,000 gallons, and that question was already answered.
Okay, so,
So, thank you.
okay, thank you.
Any other? Okay, thank you. So we need a motion now on the table, please. Yes, Commissioner.
I'll make a motion.
Kanuha.
I move that the application for special management area use permit docket number SMA 2023-00038 be approved based on the planning director's recommendation, which shall be adopted.
I need a second, please. Commissioner Naborikawa. So we have a first by Commissioner Kanuha and a second by Commissioner Naborikawa.
Chair,
Yes, and.
if I could
Director
just request that the planning department change out the exhibit number 3 in our addendum, just so it's clear on the record. Thank you.
So who are we requesting that to? You?
No, it's just.
I want to put it on record that we have been, exhibit number 3 have been given it, and it's on record. We have everything in hand.
Thank you.
Okay. Yes, discussion, please. Commissioner Paishandawar.
Yes, Director, Darrell, I have a question for you, sir. My question is, so for today's proposal that's before us, is this the same proposal or application from when from the previous director? Or did you take, basically, I want to know, did you take a look at the application? Is this inherited, and did you have the time to fully vet and review the application for us?
The recommendation, this is a little lengthy. I'll try to do what Sid said, KISS. I'll try to keep it simple, but I've been involved in this project since I started here back in 1998. So I've been very involved with this project. Seen this come before the commission many times. It's always been supported because it's in the proper location, proper zoning. Again, the only reason why it's coming to this body is because it's within the SMA. I do agree with the recommendation. I am pleased to see that the parties were able to come together and resolve their differences and come out with an agreement.
Thank you. The reason for my question is from the perspective of the public, I just want us to state, I just wanted to ask the question so that it was clear and on record.
Thank you.
Thank you, Commissioner Au.
Madam Chair, thank you. I support this motion. I think it's consistent with the objections and policies of an SMA permit. And, I think the development is consistent with the general plan. It's consistent with with the community plan and zoning codes. And on a comment side that I want to make, I'm excited about a project like this, especially on a Lee Drive. I Googled some of the hotels around the area, some of the community hotels and stuff. And, the Kona Reef Hotel was built 44 years ago. The Royal Kona was built 56 years ago. And the Hale Kona Kai was built 52 years ago. From pictures that I've seen, I don't know how it was on a Lee Drive, but it was probably pumping down there. It was like back in the heydays, and I'm really excited for that area. For the community, for jobs, for the tourism industry. I walk and go jogging down that area all the time, and the homeless is pretty bad down there. I'm a guy, and when I go jogging at night, I'm kind of worried about my safety when I drive past that area or when I jog past that area. And just all along Ali Drive, we want not only our visitors, but our local people to have a pleasant experience down at Ali Drive. And I'm excited for that place to be revived. This one project's not going to make it happen, but with the support of the community and other landowners in the area, I think Ali Drive can go back to its heyday. So thank you.
Thank you. Vice Chair, Vice Shandor.
Sure. I respect the comments that have been made by my fellow commissioners and agree that there's great potential for this project to be a vibrant one. My question is not totally answered to me in terms of economic benefit to local residents. However, I will say that because of the overwhelming testimony in opposition, it's just something that I cannot ignore. And so while we are in the general planning effort and update, I would like to suggest to my fellow commissioners is that perhaps we should delay this until the general plan update is completed, because this is a major development that will have a long-term impact on the Kona community, for which I'm a resident. And so it's not to stall this project forever. However, we are in the general planning update process. And I do believe that because there's overwhelming opposition, I cannot personally, in good conscience, ignore the volume of testimony in opposition. And so as a possible middle ground or resolution to possibly wait until we complete the general planning update?
Commissioner Rodriguez?
I have a concern about the water. I don't believe there's enough water to support a structure this big. And I have a concern about using the existing footings. And I also have a concern about building such a big underground parking. It's a disaster waiting to happen, because it's close to a tsunami area. So, that's my concerns. Thank you.
Yes.
Madam Chair.
Commissioner
So,
Al.
as a response to my fellow commissioners, this is an SMA permit, and this is not the final say. They still have to go through DPW. There's all these things that this project needs to do to pencil out economically, financially. They still have to follow laws and rules set by the state of Hawaii. If something triggers something else, like water, for example, if it triggers something else, they got to do it. Another thing, I know there's a huge cultural sensitivity about this project. And if anything arises while they're building, that's another step they're going to have to take. So in the end, it might not even pencil out. So I just want to share that with my fellow commissioners.
Commissioner Kanuha.
Commissioner Al, thank you for addressing that. And I think, moving forward to, Commissioner Rodriguez, this is the first step of many steps. They're going to have to go through a lot of steps to get to that process. The variance on what's there right now, what you address, underground parking, there's underground parking everywhere in that neighborhood, next door, Corner Reef, across the street, anywhere around there. So I think they addressed a lot of things, and this is going to be the first. This is just a small portion of what they're going to have to deal with to even get this over the line. So I think just looking at that holistically, and thank you, Mr. Commissioner Al, for addressing that.
Yeah, did you want to speak? Yeah, I'd like to speak to this because we've been doing this now for years. And I personally think we should go forward in approving this. I think that they have met all the conditions for an SMA, and that's what we're looking at here. And I think that they've taken the time to go through mediation with the neighbors, and they've now provided 3 public parking spaces. And really, when you look at it, this is just the beginning. They're going to have to go through structural engineering when they get building permits. They're going to have to go through public works. They're going to have to go through the water department. There's so many, and SHPD and anything else. So those things are going to get sussed out and examined thoroughly by the other departments. That's what those departments do. What we're being asked to do is to look at an SMA permit. So we have to look at the value of what they have put forward to us to comply with that. I think they've complied with it. I like the fact that they are going to hire local people. They're going to give people local jobs, and they're doing it with a sensitivity to the past, and I've lived here since 1970. So I think I even played miniature golf on that golf course. And so, you look back at it and you look at what it's been sitting there in the middle of our town, nothing happening, all the graffiti, all of the destruction that is there. It's already got the whole foundation there. They're going to have to prove that it's structurally sound to get the necessary permits to build upon it, to park in there. So I'm going to support this myself. That's how I feel about it.
Chair.
Yes.
Just to address the question regarding the general plan update. So tonight is the night that we address the land use chapter. One of the major components of that area of the general plan is the land use pattern allocation guide map, which directs the future growth of the island. In this particular area, it's currently in what we call resort node. In the updated general plan, the proposed map is showing resort. So it's still consistent with this particular zoning. And again, this is zoned resort. We're looking, this project is relating to special management area, and that's all we're looking at tonight. Just to keep it in perspective as far as this application. The last thing I would say is, as mentioned previously, this thing, I don't want to call it a thing, but it's quite a structure that's been unfinished for a long time. And I would hope to see some movement on that to get it fixed and taken care of. Thank you.
I agree with you. Thank you.
Chair,
Yes.
just very brief
Yes.
comment. Thank you. I appreciate all of the commentary. And they're all valid points that have been brought up by Director Darrow as well as my fellow commissioners. And in terms of community engagement, this is an important phase or engagement point, right? For which we are receiving, it's part of our duty, right? As a public commission, as a volunteer commission, to receive testimony from community. And so we are doing that. My understanding is that, again, if this is advanced, that public will have another opportunity to weigh in directly to the county council. And then again, for the general plan update, there's several points in which community can engage. And so what I'm saying is that this is an important forum. And while there might, yes, I understand that there's frustration. This is many, many years. However, it's important that we continue to receive and look carefully and seriously at all of the facts as we are, and take seriously the, testimony that's been offered today. That's all I want to say. Thank you.
Thank you, Vice Chair. Okay, so we're going to do a roll call vote then. There's no other discussion.
I just want to be clear that this is to approve with the addendum conditions also, CJ? Okay.
With stated conditions, yes.
Yeah. Okay. Commissioner Kanuha?
Aye.
Commissioner Nuborikawa?
Aye.
Commissioner Au?
Aye.
Commissioner Paishanwar?
Nay.
And Commissioner Rodriguez?
No.
And Chair DeFranco?
Aye.
Motion carries with 4 votes.
So you'll be notified in writing. Thank you. Oops. We are going to walk through them. No, we're gonna. So we're gonna introduce agenda item number 2. This is the initiator is the County Council PLCC 1-2024-000009. Bill 194, an ordinance amending Chapter 25 zoning, Article 1, 2, 4, 5, and 7 of the Hawaii County Code 1983, 2016 edition as amended, relating to telecommunication antennas and towers. The purpose of this amendment is to implement a uniform and comprehensive regulatory framework for the development, siting, installation, and maintenance of telecommunication antennas and telecommunication towers. So there's no presentation today because at the last meeting, after hearing a staff presentation and public testimony, the commissioner deferred the voting this item today. So we will take public testimony and then ask for a motion for action. So we have one public testifier today, which is Cindy Evans. And do we have anybody on Zoom? Most of them spoke before.
Chair, there's nobody waiting to testify on this item.
So Cindy, I'm just going to ask you to be succinct today, please, since you've testified before. So raise your hand and swear to tell the truth before the Leeward Planning Commission. Thank you. You have 3 minutes.
Thank you. Good afternoon, Chair,
Aloha.
Planning Director, Commissioners. Thank you for this opportunity. I'm asking today for a favorable recommendation on Bill 194. You know, 2025 is coming up, and as we see the deployment of technology in so many areas, AI, whatever is happening really, really rapidly. And one of the things and one of the reasons I addressed this issue of telecommunications and broadband is because I understood this technology was really permeating and going out into our communities. And my community asked me when I was a council member to please look at what are our standards, what are our requirements for siting these broadband 5G facilities, as well as these standing telecommunication towers. As I did my research across the states, talking to the Federal Communication Commission, checking with the FAA, the PUC, DHHL, Department of Land and Natural Resources, as you saw in my testimony that I provided, that I discovered that we have an opportunity to actually put in these requirements and standards as long as we're not doing it in violation of what's in federal law. And I am confident that what you have in front of you is not violating that law. In fact, what I think it's trying to do is to create a transparency for all of our community members in understanding what we value on our island when it comes to making decisions about the placement of these facilities. We're asking for transparency in my bill, I think much more than in the other bill. And I'm asking you to forward both of them with a favorable recommendation and let the council and the community really vet out a little bit more about what they want clearly in our code. I'm someone who, as a policymaker years ago, was the one that broke the ice on telehealth in Hawaii. I fought for the embracement of new technology on telehealth. It took many years to move in that direction, but I think this telecommunication and broadband is where we're at now and into the future. I think what we're asking for is to address it the best we can now. I think in some years to come, you'll see modifications and more amendments that'll come in this area. And so I do think that our community cares about property values, aesthetics, lighting, endangered species. They believe in equity, not putting things in a poor community, instead put them where they're best suited. We're asking for analysis. I think the stuff we're asking for can easily be provided because they have to do it anyway. They have to provide this information to the federal government. So to me, it would be good policy, and I ask for your favorable recommendation.
Thank you for your testimony. So we're going to do a motion for action. Oh, are there any questions? We're going to do a motion for actions. Vice Chair Paisandor.
Sure, I'll make the motion. I move that a favorable recommendation be forwarded to the County Council on the proposed amendments to Chapter 25, Articles 1, 2, Article 4, Article 5, and Article 7 of the Hawaii County Code 1983, 2016 edition as amended, docket number PL-CCI-2024-000009.
Thank you. I need a second. Commissioner Au.
I'll second that.
Okay, so we have a first by Commissioner Paisandor and a second by Commissioner Au. Discussion, please. Any comments?
Yeah, I would like to make a comment.
Which first, Commissioner Paisandor, will you tell us why you voted for it?
Because I believe that the applicant answered all of the questions that were put forth to them previously. And I do believe that this is going to be of great benefit to the county of Hawaii.
And Commissioner Au, will you?
So I do support this motion, but I do have concerns about it. You know, and I don't want to get into the things that I'm concerned about. But what I really like about this bill is that developers don't like it, okay? Because it's more expensive for them to build it. They got to go get plans. You know, they have more red tape that they have to go through. And you know, these cell phone tower developers make a lot of money. You know, these towers go up and they're up for 25, 30 years. They recoup their costs tenfold. I mean, I'm not a cell phone tower guy, but you know, imagine a little pole sticking out of the ground and millions of people and organizations and countries use it. And you know, that's what I really like about it. It's putting regulations, it's keeping them honest. If they're going to develop these things, they have to take into considerations a lot of different things, not only the build, but other safety, health hazards, even though it's not our Kuleana from a land use matter. I'm glad that, you know, Ms. Evans' bill is addressing all these things because it's going to keep them honest. You know, if you look at the testimonies, AT&T, these cell phone towers, they're against it. But anyway, that's my Kuleana.
Thank you.
Thank you, Commissioner.
Commissioner Kanuha.
Yeah, thank you for touching on that. Similar to that stringent process, you know, if we're gonna go do any projects here at home, we gotta abide by the law. And I think holding accountability moving forward is great. So thank you, Cindy. I know you've been working hard on this and I know it's come in front of us for, I think this is what, third, fourth time. So thank you for sending it there.
Commissioner Naborikawa.
I have a question for Director Darrow. So as Commissioner Au mentioned, there are some things in Bill 194 that are not the Kuleana of the zoning code and planning department. How will those things, if we keep those things in and it is adopted with those things in, how does that affect the code, how this is going to work?
Well, that was our testimony in regards to our presentation when we presented the areas that we have difficulty with. There's certain areas that it really is in a planning department area, right? Some of the fire issues, some of the electrical issues, some of the other areas. But the fact is that both these bills will be heading towards council. And I'm not sure what's going to happen there. It'll be interesting. I don't think we've ever had a situation like this with two similar bills going up. It may be they vote on one and not the other, approve one, or they may combine them and find the best of both bills to come out. But whatever happens, we'll try to make sure that there's a process in place, whatever it may be. It may require other agencies to be involved in the review of these. I'd like to touch upon a point that seems to be brought up all the time with applications. First of all, I'll touch upon what Commissioner Al said. State law changed recently, and it seems to always be changing, right? But this time they put a lot of pressure on the county, right? To be able to approve these types of towers within a very short time. It is much shorter than the time frame we had for the use permit process to allow it to come before the commission and be able to have public input. So it's law and we have to abide by it. And so that's what both Ms. Evans as well as the planning department tried to do, come up with a process, but at the same time, make sure that we're addressing all of those concerns. The one concern that's always comes up is health risks and health effects of towers. And unfortunately, as mentioned by Ms. Green in the testimony, there is this Telecommunication Acts that we have to follow. But my understanding is there is a great need for more review of these health risks that these towers may be having on people, because there's so many people that come out and testify that they're having health risks, yet we're being told there are no health risks. So I would just hope that in the future that there are attempts or studies or things to make sure that the people are safe, because these are going to be built easier now that this process is easier. And probably in more places. Hopefully, as time goes on, that they will make them not as obtrusive. Right now, they can be quite large. Maybe with the technology in the future, they'll be smaller and more efficient, especially in the urban core areas. But again, to answer your question, Commissioners, is there are certain areas we have concern. It's nothing we can't work out going forward. So we'll work with the council to come up with the best of all worlds and be able to make sure that whatever areas are approved, we'll make sure that the proper agency is requested to be a part of that.
Thank you. Maybe I should make my question a little more pointed, more refined. If we approve, or if a code is approved that covers things that are not under the purview of the zoning code that this is under, and there's a legal challenge at a later date, and maybe this is a question for Corporation Counsel, does it nullify those amendments? Or is it only going to be that specific amendment that's nullified?
Well, again, we're just making a recommendation now. And so that's all we're doing. At council, they'll look at this and they'll make the final decision. Our concern that areas in this bill had to do with the building code, the fire code, the health code, the flood code. And so we were concerned about that. We wanted to make sure that the areas covered had to do with the zoning code. But again, regardless, we can still come up with a process that those areas of concern are reviewed by the correct agency. Thank you.
Does that answer your question?
Yes, thank you.
Thank you. Commissioner Rodriguez?
Yes, I prefer Bill 194 because it goes a little bit further, identifying, if we're gonna put an antenna, it's gonna ask you to identify what's around it, and I think that's important. Thank you.
Yeah, and I really appreciate all the time you spent coming to see us and giving testimony, and to all the commissioners and to everybody who has testified in front of us. It is very frustrating for us to finally get a chance to speak about it and respond, to hear Director Darrow speak about the health issue, which of course all of us are aware of, and being told over and over and over again, we can't really take that into consideration because we're looking at all these other issues. But I'm glad that it's going forward. I'm glad the county council is going to look at it again. I'm glad that the people have a chance to keep inputting in it. And hopefully that we come up with something that is valuable and that is healthy for our county going forward. Thank you. So any more comments? We're gonna, yes.
Yeah, just really one more comment. What really stands out to me is, our Hawaii County Police Department submitted testimony. Out of all the agencies, to me, that was one of those important ones. And what this bill is going to achieve, and what one of the goals are, is to connect our community, especially when it comes to safety. So many of my friends live in Ocean View, and I mean, I call them and they can't pick up. They can't even text me. And I know some Kapuna that live out there, and it all kind of ties in with the health industry. And we're just creating more services. And so we cannot tell you how much we appreciate that, the work you put into it. There's still more work that needs to be done. It's not set and final. It needs to be tweaked. And like our newly planning director said, that it's going to be the county council is going to pick it apart, and it might be totally different from what it is now. We don't know. And but the goal is here. One of the goals is to connect our community in a safe way, and kind of not necessarily encourage more cell towers, but let's just do it in the right way. Maybe I'll put it in good places and correct places, and addresses a lot of different issues. So I just wanted to make that comment before we vote.
Thank you. Okay, I'm going to call for a vote then.
Thank you. The motion is for a favorable recommendation to the County Council for PL-CCI 2024-000009. Vice Chair Paishan Duart,
Aye.
Commissioner Ao,
Aye.
Commissioner Kanuha,
Aye.
Commissioner Noborikawa,
Aye.
Commissioner Rodriguez,
Yes.
and Chair DeFranco.
Aye.
The motion carries 6-0. Thank you.
Thank you, Cindy. Thank you so much. I'm going to just move us right on to introduce agenda item number 3. And I thank you for still being here, all of you. And this applicant is Kula Nea Partners LLC, PL PUD 2024-00003. Application for a planned unit development for an 8-lot agricultural subdivision and a cultural heritage area for 40.421 acres of land. The PUD would allow various exceptions from the Chapter 25 zoning of the Hawaii County Code. The subject property is located in Kuna Street, directly south of its intersection of Punavele Street, within the Kona Acres subdivision, O'oma 1, Kahanaiki, North Kona, Hawaii, TMK 37-3-007-039. We have a staff presentation, a PowerPoint by Christian K. Thank you.
Great. Thank you, Madam Chair, members of the Leeward Planning Commission. As the chair stated, this is an application for a plan unit development permit. The subject, 40.421 acre parcel, is indicated when the red star is located in the North Kona district of Hawaii Island, more specifically in the O'oma area and to the south of the Kona Acres subdivision. The proposed development is an 8-lot agricultural subdivision with lot sizes ranging from a minimum of 2 acres to a maximum of around 5 acres to allow the construction of small farms and associated farm dwellings. Additionally, the applicant proposes to create a bulk lot for cultural and archaeological preservation purposes, anticipated to be just under 14 acres in size, with no habitable structures to be permitted. The proposed preservation lot will include archaeological features slated for preservation by the State Historic Preservation Division and associated preservation buffers. Areas not affected by any archaeological preservation buffer will be used as a nursery for the propagation of Native Hawaiian, indigenous, and endemic plants for landscaping throughout the proposed subdivision, as well as for commercial purposes. Minor agricultural structures such as storage sheds and greenhouses may be established on this bulk preservation lot to support operations solely related to the nursery and maintenance of the archaeological preservation sites. The applicant also proposes to construct a private roadway to non-dedicable agricultural standards, DPW Standard Detail R25, that will be paved to a point at least 50 feet beyond the common boundary of the last 2 habitable lots to ensure access for all proposed lots. The 50-foot wide right-of-way will extend through the entire length of the subject property and stub out at its common boundary with the adjacent Homestead Road to the south to provide for future interconnection opportunities between properties. The purpose of the requested PUD permit is to promote the development of an 8-lot agricultural subdivision that avoids significant cultural and archaeological sites that exist within the property. Through the PUD permit application, the applicant is requesting relief from the minimum 5-acre lot size requirements and minimum building site average width and related requirements of the zoning code in order to properly configure the proposed 8-lot agricultural subdivision, along with a bulk lot that will be encumbered with a preservation easement and held by a single 501c3 organization, Malama o Kekaha, established in November 2023, that will ensure the protection and proper management of the important cultural and archaeological features identified within the subject property. Additionally, one of the primary benefits of the proposed smaller lot sizes is to create more affordable agricultural homestead opportunities for local families. The applicant values the tradition of multi-generational living, which has been a long-standing practice in their family, spanning from great-grandparents to great-grandchildren. This deeply rooted cultural tradition has shaped their vision for Kulane. With this in mind, the applicant intends for each buildable lot within the development to accommodate a second additional farm dwelling, provided the necessary requirements are met. So here are the requested exceptions from the zoning code. The first is a request to reduce building sites of habitable lots to a minimum of 2 acres in lieu of the 5-acre minimum lot size required by the existing agricultural 5-acre zoning district. The request to allow a minimum roadway frontage of 15 feet, minimum width for access pole for the proposed cultural and archaeological preservation lot, which will not be habitable. This lot will have direct access to the proposed private subdivision roadway. A request to allow the minimum building site area average width to be 140 feet instead of the 200 feet required within the existing agricultural 5-acre zoning district. And a request to allow a minimum roadway frontage of 140 feet for each proposed habitable lot in lieu of the minimum 200 feet of roadway frontage required based on the existing agricultural 5-acre zoning. This is consistent with minimum roadway frontage of a family agricultural 2-acre zoning district, as each proposed habitable lot will be no less than 2 acres in size. Here is the county zoning map for the subject property and surrounding area. The majority of the subject property is zoned agricultural 5 acres, which is similar to the directly adjacent properties to the south and west. Other agricultural zoning in the area is agricultural 1 acre and family agricultural 2 acre, with some single family residential zoning to the south. The state land use boundary map designates the subject property and much of the surrounding area as agricultural, as indicated by the green color, with some urban designation indicated with the pink color. The general plan land use pattern allocation guide map designates the subject property and surrounding area as low density urban. Here is the Kona Community Development Map, Community Development Plan Map, again indicating the subject property here outlined in blue. The subject property is located within the Kona urban area, but outside of any transit-oriented development area. Here is the applicant's submitted site plan, again showing access from Kukuna Street into the subject property. You'll see the layout here of the 8 habitable lots, and then the roughly 14-acre preservation lot in the thatched area. As was indicated, this private roadway will be paved to a point about 50 feet beyond the last habitable lot, and the right of way will extend to the southern property boundary. The applicants own the adjacent property here to the south, so should they intend to develop that property in the future, we wanted to ensure that there was the opportunity for roadway connectivity. Showing here also in green are the archaeological sites that have been slated for preservation. So the majority of these areas are again within that 14-acre preservation lot. There are a couple of sites here within the lots on the Mackay side of the property. These will be protected through preservation requirements that are laid out in preservation plans, and conditions of approval require that. Here's an aerial photograph of the subject parcel. As you can see, the surrounding area again are smaller agricultural lots showing residences and some small farms, with the exception of some grading that has happened to get into the property. The remainder of the property is currently vacant of improvements or structures. Here's a view of the entrance to the property from across Kukuna Street, subject property in this area. And here are some views of Kukuna Street facing Mackay, with the subject property on the left, and facing Malka with the subject property on the right. The planning director is recommending to approve the requested PUD permit with conditions. The current acting director made the final call on this one to answer your question ahead of time. With that, I'm happy to answer any questions the commission may have.
Questions at this time. So we're going to have the applicant come up. Ask you to press the thing so the red light goes on. Just raise your right hand and affirm to tell the truth on this matter now before the Leeward Planning Commission.
I do.
I do.
So just speak directly in there and state your name, the town you reside in, whom you represent. And if there's anything you want to tell us about the application, we'd like to hear it. And we just want to know that you received the background information and the recommendations in the reports from the planning department, and that you agree with the recommendations, including the proposed conditions. Thank you.
Thank you very much. Good afternoon, Chair DeFranco, Vice Chair Python Dorte, Commissioners. Happy holidays. My name is Darren Arai. I'm a land use planning consultant residing in Hilo. To my left is a representative of Kulinei Partners, Nohelani Baptista. We have received the director's background report and recommendation and read it thoroughly. The applicant is in agreement with the proposed conditions of approval. We appreciate the hard work of the planning department staff in reviewing the application. We appreciate the director's of approval recommendation, and we agree with the proposed conditions of approval as presented by the planning director. If it's okay if I.
Yes, please.
Okay. And again, we really appreciate the very, very thorough presentation that was conducted by staff. It allows me to keep my presentation kiss, right? So, but with that being said, I'll focus on some of the testimony that you heard this afternoon, and that testimony was basically characterizing this project as a desecration of cultural and historical resources. The property is owned Ag 5. It could have been carved up into 5-acre lots purely by administrative action. No public hearings necessary. No additional approvals necessary. That was not the right thing to do. The archaeological studies that were conducted, the Kapakai analysis that was conducted by the applicant, all of that led them to pursue a PUD permit, which would allow just a few exceptions, making the lots a bit smaller and making it a bit more narrow. And by just those few exceptions, it allows them to configure the proposed subdivision in a manner that keeps the current density of 8 lots as allowed by agricultural 5-acre zoning, but also provide for the necessary preservation areas and preservation buffer zones that have been memorialized in conditions, 3 separate conditions presented by the planning director, which the applicant agrees to. I also tried to figure out how best to convey to all of you that the actions by Kulinei Partners is not disingenuous or irresponsible. And it occurred to me the best way to point is to look at Nohea Baptista and her entire ohana that sits behind me. They have been on these lands for over a century. They have their lineal descendants of this Ahupua'a. Their actions, I believe, are responsible, are proper. And I think we're hoping that your support of this planned unit development permit will help them realize the dream for this property that has been long in coming. So I don't know if there's anything.
This has been a really long time coming, and we're grateful, so grateful to be here. If I never do another PUD for the rest of my life, I will be elated. But we are lineal descendants of the petitioned area and direct descendants of the 2 adjoining parcels, that were purchased from the Kingdom of Hawaii by my great-grandparents. When my dad and his partner were able to reacquire the land, it had been rezoned as urban, with the previous project planning to construct 270 lots on the 3 parcels. They realized that although that project would have been very lucrative financially,
It would remove all the archaeological sites entirely and likely destroy whatever native plants that were still remaining in the area. As a lineal descendant, my dad realized that that's not something he could allow to happen. We grew up in the Kwaniki Ahupua'a. We've been raised there together, multi-generations living on the same property. And I know that we're very fortunate to have that. Before my tutu passed, she lived there. Two of my siblings lived there. I lived there. My parents lived there. So there's a sense of family, and that has become the gathering place for everyone in our family. That is the concept and the driving design behind what we did with Kulane. Everything was intentional. We wanted to make sure that the archaeology stayed protected. My dad has a huge passion for native plants. He's designed different lots and roads so he could protect the llama trees. So I'm grateful for what you said earlier about the lineal descendants. And I'm grateful that we have an opportunity to speak on the testimony that was given, because it couldn't be further from what our plans are. We are very passionate. We are very resolute in what we have decided to do to preserve the culture there. The archaeological sites have been situated so that they stay in a green space, so that the responsibility falls on the 501, which is like Ohana 501, that's going to take care and preserve it. Nobody can go in there and mess around with them. But it was done, and it's probably, when you look at it from a planner's perspective, it doesn't make sense how we did it, but from a cultural perspective, it made all the sense to us. So we did have to go before land use to rescind that zoning. And I know everyone thought we were crazy, because who gives up urban zoning? But people that have different intentions and intend to protect the area, they give up urban zoning. So I really hope that we get a favorable decision from you today, but I also hope that when you guys leave, once you really look at our project, you can feel good about what we're doing there as well, and feel happy that you were able to give us a favorable decision.
Thank you. Are there any questions for the applicants? Vice Chair Paisha, Commissioner Naborikawa.
Thank you. So if I understood you correctly, Malama Okekaha is basically all the rest of you here. Is that what it is?
I personally am not in it. There are family members. There are other outside members outside of the family that are in it, but it was formed to protect and preserve the culture and the native plants in the area.
So basically, the lineal descendants are the ones making the decisions on what happens in this archaeological preservation area.
Correct.
Okay, thank you.
Vice Chair Paisha.
I'm glad you asked that question, Commissioner Naborikawa, because that is hopefully this becomes a model.
Yes.
For the rest of our moku. My question is, you pointed out you didn't have to. From one point of view, it's not lucrative, right, to redesign and reconfigure your. I think this is a wonderful project. Can you just elaborate a little bit more as to why, again, that you want to reconfigure this proposal and give up some of the ability to develop?
So when my dad was going through the archaeology portion of this, which is very extensive, they were talking to him about removal and digging out trenches and mitigating those sites. And immediately he said, stop. Once you remove that archaeology, even if it's done the correct way, it's gone. It doesn't exist anymore. So his idea was to leave all of those things intact. On top of that, when it comes to the native plants, my grandmother was born there. They grew up there and they farmed over there, and it's not a very hospitable place. But what he wanted to do is take the plants that are native to that dry area and try and repopulate the area, pull the invasive stuff out, but leave standing the things that were already there. I'm fortunate, because it's fortunate for me, because he grew all these trees that I need for my daughter's hula. It's great, But the idea is that if we don't respect what was there and try to perpetuate it, at some point it's all going to be gone.
Thank you. I just wanted that for the record. When your project is fully operating and, you know, your 501c3 continues to do what it does and expands. I hope that those who are, those developers and folks that are interested in developing these kinds of proposals can clue into your folks' model and strategy. So thank you.
I hope so too. Thank you.
Chair.
Wait,
I just a quick comment, if I may. A lot of the testimony by Nohea has spoken about her father, so I wanted to, quickly recognize him. He's a quiet man and he wanted to sit in the back, but it's Mr. Robert Lee right here is like the patriarch of the family. I've known him for many years, a wonderful guy. He talks about how this process has been so time consuming and laborious and how he's not getting any older. And I really don't believe him because any guy who has more black hair than I do is not old, but at the same time, I did just wanted you to recognize him because he has this vision and his entire Ohana has embraced that vision. So
yeah, mahalo. Thank you. Thank you so much, all of you, for being here and doing what you're doing.
Thank you, Chair. Yeah, I was fortunate to be a part of what's happening here. In 2019, when you folks came before the Land Use Commission, I was able to be there with you folks and with Dwayne by your side. And that was the beginning of seeing this dream come true. And I'm just so happy to see it come true today. Thank you.
Thank you. Thank you. I don't think there's any public testimony, is there? There's nothing on Zoom, no, nobody.
No testimony on Zoom, Chair.
What? There was two people talking. Okay, I don't think that there's any testifiers, is that right? If
That's
there's
right.
not- That's not, we're gonna make a motion for action then.
I'd like to make a motion.
Yes.
I move that the application for planned use development docket number PL-PUD-2024-00003 be approved based on the planning director's recommendation, which shall be adopted with stated conditions.
Kako'o.
Vice Chair.
Second.
Seconds. So we have a first and a second. We're gonna ask for a roll call vote. Oh, discussion.
Madam Chair, just really quick.
Discussion, yes.
Yeah, exactly what Mr. Rice said and the applicant, this is a very unusual situation. We live in a very expensive community in Kona and people are always trying to get ahead and make money. And for the applicant to do this, and it's really unheard of. But I commend the applicant and your Ohana. You're gonna enhance our community by doing this. So thank you.
Commissioner Naboy-Kawa.
Thank you. So I was looking this over. The planned use development gives applicants the opportunity to do something like this out of the box, think out of the box. You and your Ohana has set aside about a third, a little over a third of the property to be as an archaeological preservation area. I think this is a win-win for everybody. We get to preserve the culture and history of the area. Your family gets lots that they can live on, and they can, do the things that they've done before on that property. And you've got basically 8 building sites so that your extended Ohana can live there. And I'm totally in support of this. Thank you very much.
Thank you. I know I'm in total support of it also. And Director Darrow, thank you. And thank you to the planning department for being supportive of projects like this, that seeing this it makes all of our hearts feel good. Yes. And to see the generations present, it's really wonderful. Yeah. Thank you. Commissioner Paishandor.
Ai, e ola la hawa ia na wau. Na laila he leo mahalo ia o ko e na kupa na pula o nei aina. E ola no ka inoa o Maluihima. O ko na kupa'a o Kohanaiki, o Oma, o Kiahuoluma. E olu e ho'omau I ka oko hana nui. No ka pono ka aina, no ka pono ka wai, no ka pono kako na kanaka. No laila ho'i oko me ka malu I ke aloha, I ka mana, a me ka no'eau o ko oko kupuna. E ola. Mahalo. For everyone, I just basically said, I acknowledge the kupa, the lineal descendants of these Aina, that they may continue to do, I ask that they continue to do their good work on behalf of their families and their future descendants, on behalf of all of us, and really just thank them, and especially the kupuna of their ohana for being such role models for all of us. Mahalo.
And just to touch on what she said, Tutu Maloihi would be very happy.
So we need a roll call vote.
Thank you, Madam Chair. On the motion to approve, Commissioner Kanuha,
Aye.
Vice Chair Paishandwar,
Aye.
Commissioner Ao,
Aye.
Commissioner Noborikawa,
Aye.
Commissioner Rodriguez,
Yes.
and Chair DeFranco.
Aye.
Thank you, Madam Chair. The motion carries with 6 aye votes.
Thank you. You will be notified.
Thank you, commissioners. Happy holidays.
We have one more agenda item. Agenda item number 4. We're getting limited on time. I'm thinking we could do this. What do you guys think? Shall we go for it?
Yeah, you got it.
Okay, here we go. Applicant Greg Gillian and Kathleen Kissel, PL SMA 2024-000066. Application for a special management area use permit to demolish an existing single-family dwelling and construct a new single-family residence on approximately 12,294 square foot parcel located within the special management area, the SMA. The subject property is located at 69-1928 Puako Beach Drive, Puako, South Kahala, Hawaii, TMK 36-9-006014. So we have a staff presentation, PowerPoint by Derek Harbaugh.
Good afternoon, Commissioners. This application is a special management area use permit application PL SMA 2024-00066. It's located in the Puako Beach Lots on TMK 369-006-014. This is a map of the location. I don't know if you can see my mouse, but it's located on the Mackay side of Puako Beach Drive. The applicant's request is to demolish an existing 1,400 square foot single-family dwelling that was constructed in 1956. In its place, they are proposing to construct a new 2-story, 3,825 square foot single-family residence, which includes 3 bedrooms, 3 bathrooms, 1 half bathroom, a kitchen, a living room, an interior elevator, pool and spa, and an ADA compliant accessibility ramp. Portable water is by an existing Department of Water supply meter. Concerning the wastewater, there is an existing cesspool that will be closed and a new advanced aerobic wastewater treatment unit will be installed. This is the county zoning. It's zoned RS10 and it's surrounded by open zoning. And then across the street is Ag 5A, Mauka of the properties on the Mauka side. The state land use is urban. And the LUPAG map is low density urban, surrounded by open areas. This is the subject property, an aerial view. And this is another aerial view. And I just kind of wanted to point out the observed shoreline. which is different than the shoreline that was certified for the property. So I'll talk about that in a moment. This is the certified shoreline for the property. It's against an existing non-conforming legal seawall. Originally, the applicants proposed to utilize a public shoreline access that is to the north of, directly north of the property. But what we found, what the department found was that when we went out there, people actually use these road stub outs for parking and access into the Pucco Beach area. This is an example of just when I went out there that one afternoon, people were parking there. There are other road stub outs that do have access to the properties from the road stub out area. But as you can see here, parking is available still, and it is not blocked. And again, here's another one example where people were able to park and access was still available to the property. Another example, while I was out there, somebody needed to be rescued out of the water, and that road stub out was used for that. I'm going to quick bounce back up here real quick. So we brought this up to the applicant, and they immediately, and we had a lot of testimony from the concerned neighbors, and they immediately changed their plans to have the access be off of Pucco Beach Drive. And so that took care of pretty much all of the public testimony regarding that. This is the floor plan for the lower plan. There's a 2-car garage. And this is the upper plan. And that circular portion of the building is the ADA compliant accessibility ramp. This is a view from the north and the south, where you would enter the property. The property entrance will be located just south of the telephone pole in that photograph. And the director's recommendation is approval of PL SMA 2024-00066 with the stated conditions. And I'm available for any questions if you have any.
Can you go back to the slide that shows the neighbors in the neighborhood? Let's sort of go back to that overhead thing. One that actually shows an overhead. Yeah.
Yeah.
Okay. So when you put the building on there, does it take up the whole lot?
I'm sorry?
Is the building, the new structure, does it take up the whole lot?
No, it will not.
Okay.
In fact, so the current structure on the property was allowed to have a 20-foot setback.
Yeah.
And current regulation doesn't allow for that. So the
Right.
setback is going to be 40 feet from the
So the whole
seawall.
building comes down.
And then there's also then the front yard setback, which is adhered to as well,
Okay.
as well as the side yard setbacks.
You go back to the design of the house on the architectural drawing. Thank you.
And the initial, I'm sorry, the initial plan
No,
or the this plan?
is this the plan?
Yes, this is the site plan.
Okay. Are there any other questions? Commissioner Naborikawa?
Just so that I'm clear, the blue part is the swimming pool, and that is basically in the footprint of the previous house, so it's not any closer than 20
Yes.
feet to the, and the physical house itself that's going to be constructed is going to be 40 feet from the shoreline. Is that correct?
It is.
Okay, and then you've got 2 front yard setbacks, so one from the upper part of that photo and one from the right-hand side.
These are the one to the top of the picture and to the bottom of the picture. That's the side yards. And then the front yard setback
Oh,
would be up
okay,
the
sorry.
stretch. That's okay.
Different terminology. I'm used to having two, when you have two accesses, it's, you then have two front yard setbacks. Sorry. Thank you.
Yes, Vice Chair Paishal.
Yes, thank you. Do you have do you have a picture of the existing legally non-conforming seawall by chance?
I do not in this presentation, but let me see. Yeah, I don't in this presentation. Here's an image. On my computer. Of the side. And what was this was an excellent image. This is our concern was with the observed shoreline that was happening on the road stub out. The 40-foot setback would have been closer to where the current parking is. And they had proposed an access gate. And that would have been in the shoreline setback. So they had moved it.
And again, all of the concerns that you've planning department has previously raised have been addressed, correct?
Yes.
Concerning this seawall?
Yes.
Thank you.
So if there's no other questions, right now, we're going to have the applicant come forward. And I'm just going to swear you all in. So if you'll all raise your right hands and you turn that button back on. Okay. You swear to affirm to tell the truth on this matter now before the Leeward Planning Commission.
I do.
Thank you. So we just remind you, you're going to have to speak directly into the mic. So when you do speak, state your name and the town you reside in and whom you represent. So my question is that you've received the background and the recommendation reports from the planning department and that you agree with the recommendations, including the proposed conditions.
Aloha, Madam Chair, Planning Commissioners, happy holidays. We'll try to keep it brief. Thank you very much for your time. Sorry, talk right into the mic. I'm John Pippin, Land Planning Hawaii, here assisting the applicants, Greg Gilliam, Kathy Kissel. Also to my right is Kurt Klein, the project architect. I myself reside in Honoka'a here on the Big Island. We have received, much appreciate the work that's gone into this application, reviewing it within the planning department. We agree with the proposed conditions and really appreciate, again, your review. I just have a few brief words that we want to present to the council, the commission, and then we'll open up to questions. So I'll start with the applicant, Greg Gilliam. Please introduce yourself, state where you live.
Just move the mic over. There you go.
My name's Greg Gilliam.
And I'm Kathy Cassell.
You have to get right.
Leaning forward.
And I'm Kathy Cassell.
Thank you.
Go ahead. So Kathy and I have been married for 31 years, and we've been full-time residents of the island of Hawaii for 20 years. We've owned a couple houses. Right now, our current residence is in Maulani, but we've always really want to look at moving into the Pu'uko area because it's more residential. We've been here 20 years. We want to get that experience.
What else drew you to Pu'uko?
So we really started looking there about 10 years ago and saying, where would we want to be? And we want to be towards the southern end because we love the sunsets. And Pu'uko, if you know, is a big curve. At the north, it sort of faces towards Kauai, but towards the south, it faces more. So we kept our look down there and looked for a long time. And then we finally found 140 or 69-1928 Pu'uko Drive and decided to buy that property. And when we bought it, it's a really cute house, but it's pretty small to live there full time. It's not clear that that house was ever designed for full time living with ohana, with family, with, you know, we have our lifestyle is an ocean lifestyle. We have a pair of OC1s, we have a pair of SUPs, We have scuba diving equipment and snorkeling equipment and just the house, we have clothes like all of you. And a house of that size just cannot really accommodate what we wanted. So, and the last one is I'm a do-it-yourself type of guy. I do my own repairs on my house. I have an extensive garage. I got not every tool in the world, but I have enough tools to keep it up myself, and that requires storage.
Awesome. For this property, are there any private CC&Rs, covenant codes, restrictions?
Not that I know, of, no.
No. Would your use of the property restrict public access in any way?
I want to clear something up. Kathy and I support open access to the ocean. We would never block the ocean, just not our style. So we were very offended when some people said that we were looking to block the ocean. We found out that our driveway was going to impact the parking, so we changed it. So we think we solved the problem with the parking and ocean access.
Anything else you'd like to say to the commission?
No, we're just very excited to get this to the last house and just live here in Puco instead of Montalani.
Thank you.
Thank you. And I'll share the mic here with Mr. Klein, the project architect. Please introduce yourself and explain your qualifications.
Hi, my name is Kurt Klein. I live in Honolulu. I've been practicing architecture for 35 years, designing homes for people like Greg and Kathy. And so this is their forever home. They want to live here and spend the rest of their years in this house. So it was a really important project for us. The house is just reflecting their wants and needs. And again, we were respectful of the neighbors that had concerns over access, and also we wanted to make sure that we redesigned those things to make that access complete and open.
And do the current plans meet and respect the county setback requirements?
Yes, everything is within setback compliance, also height compliance.
And how would you describe the general architectural character of Puco?
You know, it's varied, and that's what I like about Puco. We've done some projects there, and I like the fact that there's a mixed context and mixed architectural style. Pretty much every style that you could expect to find is on Puco Beach Drive. The style of this house is modern, and there's a few examples of modern as well. So again, it's just varied context within the street.
And are there other two-story homes nearby in Puco?
Yeah, there's a mix of two-story and one-story homes.
And would you say the design complements and conforms to the character of Puco?
Yeah, to the extent that there doesn't seem to be an overriding character, yes, I think it does.
Very good, thank you. I'll just take a few more moments to clarify kind of the process that brought us here. The setbacks on this property are a little unusual given that it's a corner lot and a shoreline lot. So we have the 40-foot shoreline, and then there are in fact two front setbacks. So 20-foot from that area used as parking, which is a public road. And then the main drag of Puco Beach Drive, there's also a front yard setback there. We had initially requested to use the side yard or the parking side as a side yard and treat that as that setback. Neighbors didn't like that, so we dropped that. We forgot about that, withdrew that. So we're just respecting all of the setbacks now. And even though it results in an over 70% loss of basically the land that's usable on this lot. So they're working with what they have. When concerns arose again from the driveway and the potential impacts to public access and parking, scrap that. The access is now from the main Puco Beach Drive. They've been sensitive and flexible to this point, and they really just want to be good neighbors, and you know, asking them to completely change the design of their home is really too much. And it's not pertinent to the SMA. It's not the authority of the SMA to say what style your home is. Architecture is art, right? And art is in the eye of the beholder, right? What someone likes, someone else may not like. But the view impacts from this project are not pronounced. There's already an existing home there. And this would fit in with other existing developments in the area. What we haven't heard about yet are the benefits from this project for the SMA. We're protecting that public shoreline access. We're not going to interfere with it. It's now a condition of this SMA permit number 13. So it's on the record. Nothing's going to change from this project relating to that access. Furthermore, we heard the testifiers today and how the public uses this area, and we're very sensitive to that. Having a cesspool, an old cesspool this close to the ocean water is not a good thing. So we're going to close that cesspool. We're going to upgrade it to the best current technology, which is an advanced aerobic individual wastewater system. That's going to help to incrementally clean up the nearshore water quality there, which is a great benefit to Poco. And we're also retreating from the shoreline. We're taking a previously permitted 20-foot setback home, moving the new home outside the 40-foot setback. So I think this ticks off a lot of key boxes for SMA review and in the positive. It's not just that it's not impacting, it's impacting positively, right? So with that, we'll request your favorable consideration of this application. Welcome any questions you might have. Thank you much.
Thank you. Commissioners, do you have, Commissioner Au?
Yes, I do have a question. So the community is not happy with the project. So can you just talk about that? And, I appreciate you, Mr. Gilman, expressing the importance of beach access, because it's very important, and I'm sorry that you had to feel that the community was mad at you for that. So maybe just talk about the community, maybe the HOA. Did you present it to your HOA? Like how did all this come about? Because when I look at these signatures, it's the general public. It's not necessarily the community.
Yes. Thank you for your question, Commissioner Au. The process has evolved, right? As always happens in a project like this. You have initial plans, they go through reviews, they get altered. You have changes, they get reviewed and they get altered again. So that's what's been happening. It has been in response to community feedback. So we have been open, we have been working, sending these plans to the HOA, and unfortunately, the community association, right?
Oh,
Community association, pardon me. Unfortunately, as happens from time to time, there can be some misinformation or disinformation about a project. Neighbors may have concerns about view impacts to them from their home, but they'll promote concerns or controversy about a project and couch it in terms of public access. So we think that we've done everything that we can to mitigate those concerns, moving the driveway, respecting all of the setbacks. And again, the public benefits that this project brings should really come to the front.
Only one
Any other-
question.
Commissioner Kanuha?
Did you get that feedback from Department of Water Supply?
Yes. And again, it's like, this is an old home. It's got old landscaping irrigation, leaks happen, and that's all going to be corrected in the new construction.
And to touch on that, we commend you. The community is huge in what you want to do and saving that public access and everything you guys are doing. That's great. And we appreciate you bringing that to attention and putting that on the record, because there's a lot of hearsay that goes around in the community and people start saying things that might not be true. And, I could understand why it would hurt your feelings, because it would hurt mine.
Thank you.
Any other questions? No? Can we get them? There's no testifiers, I don't believe. There's no testifiers on Zoom. Okay. So we need a motion for action, please. Commissioner Au.
I move that the application for special management area use permit docket number SMA 2024-00066 be approved based on the planning director's recommendation, which shall be adopted.
Second.
Seconded by Commissioner Kanuha. So discussion, please.
I just want to
Vice
thank
Chair.
the applicants again for putting forth solutions that have addressed questions and concerns from planning department and from community. Thank you for taking the time and effort to do so.
Commissioner Rodriguez.
I'd just like to congratulate you and, I built my house about 8 years ago and it's hard work and, me and my wife almost got a divorce because she's always changing colors and stuff. So thank you.
Just want to make a quick comment. This property was purchased, you purchased it from the prior owner when? Right, so the applicant actually inherited this problem from the other landowner. If you look through the documents, Mr. NC was getting public outrage and he wasn't even doing anything either. You just say public access and like, I'm gonna get mad, right? So, but I appreciate the current landowner, you probably knew what you're getting into. And for the public to accuse you of doing that, you're an ocean person and we are all ocean people. So I appreciate you. Thank you.
Thank you. Okay, we're going to call for a roll call vote.
The motion on the floor is to approve as recommended by the planning director for PL SMA 2024-00066. Commissioner Au.
Aye.
Commissioner Kanuha.
Aye.
Commissioner Noborikawa.
Aye.
Vice Chair Paishan Duarte.
Aye.
Commissioner Rodriguez.
Yes.
And Chair DeFranco.
Aye.
Motion carries 6-0.
Great.
Thanks a lot.
Okay, you'll be notified.
Thank you all
in writing.
very much.
Thank you so much.
Have a great rest of your day.
Okay. We're going to do election of officers really quick. Should we do election of officers really quick? Defer to you. Defer to you. Okay, so we're gonna just do election of officers really quick here. So I'm gonna bypass the rhetoric and say, I'm gonna move to nominate somebody as the new chair, Dean Au. I need a second, please.
Second.
I second that.
Seconded by Sean Duarte. Any discussion? We need a roll call vote. Well, nobody said they wanted to discuss it. Did you want to discuss it? Okay, so we want a roll call vote, please.
Sorry, Chair, I didn't hear who first and seconded.
I made the motion
Okay,
for
And I
Dean
seconded
Au
it.
for the new chair, and it was seconded by Vice Chair Paishan Duarte.
okay, thank you. Okay, Chair DeFranco
Aye.
and Commissioner Al,
Aye.
Commissioner Kanuha,
Aye.
Commissioner Noborikawa,
Aye.
and Vice Chair Paishan Duarte,
Aye.
and Commissioner Rodriguez.
Yes.
I'm sorry, did I miss anybody?
No, you got everybody.
Did I
So-
miss you?
No,
I'm so sorry. Okay, the motion carries.
okay. And I'm going to make another motion for Vice Chair for Commissioner Noborikawa. I need a second, please.
Second.
Seconded by Commissioner Kanuha. I need a vote, please. Oh, discussion?
Yeah, just a quick discussion. I want to thank the outgoing chair and vice chair. And I would like to feel sorry for the incoming chair and vice chair. Thank you.
Oh, you'll love it. You'll love it. Okay, we need a roll call vote, please.
Okay, Chair DeFranco,
Aye.
Commissioner Kanuha,
Aye.
Commissioner Al,
Aye.
Commissioner Noborikawa,
Aye.
Vice Chair Paishan Duarte,
Aye.
and Commissioner Rodriguez.
Yes.
Okay, the motion carries.
Great. And the planning director's report, on the SMA determination and minor permits issued by the planning director for November 24. The SMA report for November was distributed via email. All the commissioners received that? Yes?
Yes.
Okay. All right, so we on to agenda items for the next meeting. Is there anything that anybody wants to put on the agenda item for the next meeting? Commissioner Noborikawa may have a request.
I would like to have a discussion about having, since we have to change the letterhead anyway with an incoming administration, to make a recommendation to the mayor to have Olelo Hawaii listed as for each department and other groups that have letterhead like the Planning Commission that have the both English and Olelo Hawaii as part of the letterhead.
Mahalo nui.
Thank you. Okay, announcements. The Leeward Planning Commission's next regular meeting is scheduled for Thursday, January 16th, 2025, has been canceled. And the next regular meeting is scheduled Thursday, February 20th, 2025, here in the County Council Chambers in Kona. The public may also testify via Zoom. The date and venue and the meeting are subject to be changed. Are there any other announcements from the staff, please?
No, Chair.
Okay, then we have an adjournment. We need a motion to adjourn, please.
Motion.
A second
Second.
to the motion to adjourn.
Second.
Second, it's first and second, and all in favor say aye.
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 Any opposition? The meeting is adjourned at 4:55.
Right now.
Right?
So the
And
special,
so our next meeting starts at 5, but we're gonna start it at 5:30.
oh, it's with the 17th is canceled. Because that was.
So we're gonna eat as fast as we can and come back. Any comment? That's it. Okay.
Second what?
I did, and then the bar call.
The board call, second.
Barbara didn't get to say farewell.
No worries, she can do it on her next one. Well, no, she'll do it on her last one.
The closed transcript caption copy will be available. This meeting will be ending now.